Yes, Mrs.
That item, my lord, that school matter, item 33. Just the party has shown me some documents, my lord. I'll examine it and let it come, my lord, in quick date next week.
Okay. Item number?
33, my lord, the Dasiram Deka.
Kasinam Deka.
Yes.
On the prayer of Mr. R.P. Sharma, Learned Senior Counsel, list this matter again on 24th. 24th. 2020. For motion.
I
Yes.
think you mentioned item 32. Next week, my lord.
Wait.
No, my lord, actually, file is not with me. It's earlier, Barnali Chaudhary was outgoing. File is with her. So I could not collect, my lord. So next
On
week,
the
my
prayer
lord.
of Ms. K. Devi, Learned Counsel for the petitioner, list this matter again on 22/4.
Highly obliged.
Item number 4. The parties are not interested, my lord, to continue the maybe we don't. Item number 4.
You are for
I'm for the petition only.
item number 4,
Yes, ma'am.
but 5 will remain. 5, it's stacked to 5.
Oh, no, only 4. That
Do one
Sarkar,
thing.
man, some Sarkar.
Do one thing. Just be here. It will be called up.
Yes,
immediately.
Joshi
Just be
Sarkar.
here. Joyce Sarkar, just be here.
Yes, my lord.
Wait, please, Your Lordship. I beg to mention item number 9, my lord.
Hmm.
That is all pending matter, my lord, but my senior, Mr. C. Chaudhary is not keeping well, my lord, so some time may be given, but
It's not yet recovered.
recovered, my lord, but not
Okay.
able to.
When do you
continue.
want it?
My lord, after 4 weeks, my lord. Not
2012 matter.
I'll do if he is not able to.
You do it.
Yes.
Because 2012 matter we can't have.
If he is not able, then I'll do, but on next.
No, 4 weeks will not adjourn.
Then 2 weeks, man.
We'll have it next week.
Yes.
On the prayer of Ms. A. Kayan, list this matter again, 9 day. Again on 25/4/2024.
Yes, man.
That's fine. Agree for transport department is matter.
Very pretty, lord.
Ms. M.D. Bora, the Learned Standing Counsel, Transport Department is present.
May I please, your lordship, I pray for listing of this admission matter, my lord,
Admission matter.
regarding illegal appointment of the.
Okay, any listing matter, if not for today, just give it to him. He will list.
May I please, Your Lordship?
Hmm.
Lordship, in respect to item number 12, Lordship, we have filed an additional affidavit today, Lordship. Lordship, call for the records. In
Ankit
terms of,
Johri.
yes, ma'am. In terms of-
Additional affidavit for what?
Lordship, in terms of this honorable court's direction as to the vacancies position, Lordship. Pursuant to.
Okay, get it. Anybody?
My lord, I beg to mention item number 25, my lord, on behalf of A. Deka. He is in bereavement, my lord. Let it come next week, any day. 25.
Yes, what do you want?
Any date, my lord, next week. A. Deka has some difficulty. We will
But the respondents have also not filed any affidavit here.
not ever.
Do one thing. We'll not pass any adverse order. We will ask them to file an affidavit. I've made a note.
Please, Your Lordship, I beg to, sir, may I please, Your Lordship, in item number 16, the Standing Council T board is out of station because of some personal difficulties. Kindly adjourn the matter for this week.
13 matter.
16.
No, item 2013 matter. Have you informed the petitioner?
Taken the consent of the.
We'll have it next week. On the prayer of Mr. S.P. Chaudhary.
As Dev,
Yes?
my name is not.
S. Dev. Learned Standing Council T board list this matter again on 23/4/2024.
Wait, Mr. Lordship. Lordship, I beg to mention for listing a content case.
May I please, Your Lordship, Lordship, item number 3, kindly, pass about the test.
Item number 3.
No,
There is 2 and 3 together. Wait,
It's for delivery of order.
wait.
Because of my senior counsel is not.
We will not do anything. Just wait. Let the matter be called.
Today's daily course list, delivery of order item 1.
Yes, Mr. Sharma, anything to add? Nothing. Huh?
No, yes.
So we will go as per the last times. That 5 lakhs thing we will direct you to repay to him. Other part will remain. That punishment will remain. Recovery we are stalling because even in the criminal case, it was not.
Although your lordship, criminal case cannot be equated with the disciplinary.
I'm not on that. I'm on the factum.
Yes, sir.
On the
And,
factum.
It is not the
See,
constitution of the.
the question is whether he has stolen that money. The proceedings of the criminal case is very clear that he has not.
But it is.
And your finding is also not there. Your only finding is that the door cannot be opened, and that was done behind his back. These are the two circumstances.
But it
We'll
is-
pass on this.
It is missing from his hand. Your lordship.
Huh?
The amount is being given to him, it is proof.
See, the other parties also are responsible who were there. Your bank manager immediately allowed these customers to move out. You could have stopped them. Anyway, this was. Possible.
Item 2 and 3.
Yes, Mr. Kaushik, the documents you have got. Just check up whether that application forms are there.
Individual application forms are not there.
Then that is the thing which I have been asking you for I think the last 1 month. Just show me the file.
This record contains the minutes of the district scrutiny committee and the state level.
Where are the materials which were there before the district scrutiny committee?
That is not there.
What are these records, Mr. Kaushik? What are these records?
The
Huh?
minutes of the district.
You have to send to High Court, so you collected certain papers, put it in a file and just forward it to me. That's not the order of this court.
In fact, Milord, there is no application individually by any of the candidates.
There would be.
No.
There would be a particular submitted by the
particular
principal.
submitted by the headmaster.
Where is that? It's not on record.
No, in our epidemic also that we have done it.
Huh?
122, maybe 122. In our epidemic, we have it.
And just take out the concerning this school.
Well,
One 122 of which file?
In our epidemic, in 4564.
4564. 4564. 4564 page.
122.
Okay. You have it. Particular schools.
Well,
Just give me that.
The orange flag mark.
Huh?
The orange flag.
Orange.
First one, the first district scrutiny committee which did not bear the signatures.
Hmm.
And the last orange flag is the district scrutiny committee which bears the signatures of the my committee.
This is a common problem.
With Dhubri district. This had happened in Dhubri district. We had to cause an inquiry also to that effect.
Keharbita Emi Madrasa.
My lord.
And the second one bears the signature.
Bears the signature.
But with the signature, particulars have also changed.
In fact, in this.
Mr. Talba, your client's name is?
Abul Hussain, my
Abul
lord.
Hassan.
In the earlier proceeding, I challenged my lord,
Hmm.
saying that, my lord, two candidates from the same stream, that from the language stream, my lord, has been provincialized.
Hmm.
And that was, my lord,
What is Zohirul Islam senior to you or junior to you?
my lord.
Zohirul Islam?
No, I am from social science, my lord.
Social science, I'm saying. Zohirul Islam is senior to you or junior to you?
My lord, he is junior to me because there is no contest between
Zohirul-
that person with me, my lord. Only the contest is with the petitioner and the private respondent
No, no,
with
no.
regard to language, my lord.
There is that's why I wanted the records.
He is not in the picture, my lord, the Zohirul Islam. He is neither of the, nor a respondent, my lord, nor a petitioner.
Well, his services have not been
No,
provincialized
no,
also.
no, he is not in the picture, my lord.
But why his name is figuring in the DSC's report?
In fact, my lord, his service was not provincialized. Service was provincialized, my lord, of the.
Is it in
land
the
of
first
Mr.
column
Khan.
or is it in the top column or the second column?
Top column. Earlier, his name was not there. The name of the petitioner was there. Okay. Mr. B. Kaushik Lanat, Standing Council, Elementary Education Department has produced certain paper, a file containing certain recommendations of the District Scrutiny Committee. So, the same is taken on record. Yes, madam.
I think that item number 3 by Mr. Madam. But even the opportunity will be taken by some needs to be added by it's not with
Saturday.
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 Please, Lord.
List this matter again on Saturday. Just retaining it. We'll pass the orders. Saturday.
Saturday for orders, my lord.
Orders for. Now nothing more is to come
Yes, yes. Delivery of order.
for delivery of orders.
Supplementary course list, delivery of order item 30.
Anything, Mr. Chakraborty? Nothing. So we'll close it.
The two things, of course, even on the last vacation that I had pointed out is that transporters were not examined.
Need
And,
not be.
and from Bangalore, no official.
That's why the counter question was, show me the document by which you took the vehicle to Bangalore.
No, that reply, my lord, would be the same that it was driven from Jodhpur to, and the officials from Bangalore were not examined. These are the two things which still perhaps,
No, it will not material. It's not material.
because in a
Disposal.
public.
Delhi course list, top of the list, item 4 and 5.
Please, your lordship.
Mr. Sinha wants to withdraw the other matter. Good for you. WPC 2732 2014. Mr. B. Sinha, done it. counsel appearing for the petitioner submits on instructions that the petitioner does not desire to press this matter any further. So accordingly, the writ petition stands dismissed on withdrawal. Interim order, if any, stands vacated. Agree to, huh?
In
Yes,
the other matter, Lordship was pleased to call for instructions, my lord.
yes. What is this?
Also, Lordship, order we have been asked.
Malha, Malo, same?
Lordship,
Jalo Malo, Malo, same? What is your stand?
Lordship, I have to sort some time.
Why?
Getting instructions.
And what is this nature of this order? I don't understand. Your scrutiny committee's order,
Lordship,
all hearsay. All hearsay.
Lordship,
It says somebody said so, deputy commissioner said so. It is for them to go make that anthropological study. They have not done that.
but the scrutiny committee used to act as per the order, means as per the report received from the deputy commissioner. Or
Then that can be done by anybody. Have you seen Madhuri Patel? They have to apply their mind.
Lordship, that is
There has to be an inquiry.
inquiry, yes.
Because she could not produce the documents, you have held that, no. That's not the way you proceed.
Lordship,
Mr. Nair,
Madam.
we will set aside this.
Madam.
We'll ask them to do it in the
Madam.
manner as contemplated under Madhuri Patel.
Right.
Right.
Lordship,
Because the only problem was the other case.
Madam.
Because it would have had a bearing.
Madam.
Moment I dispose of this matter, then her right would have
Yes.
revived. Now that that is withdrawn, we can interfere. with it. Disposal.
Right.
Deeply of this.
Item 6,
Yes.
What's the middle? My petitioner, your lordship, he was been dismissed from service due to
Where is Mr. Roy?
on the last occasion, this honorable court has appointed me on the 3/2/2006 to 4/11/2006, the leave of absence. Why I have been leave of absence. What- My humble submission before this honorable court without any further inquiry, where there is a rules.
Mr. Gogoi,
Lordship.
this episode of your leave started from 2006,
Lordship.
right?
Lordship.
As per your own stand in the writ petition, your earliest detection of the schizophrenia is sometime in 2008. And the doctor's certificate, if we go by Dr. Ghosh's certificate, 2009, right? Now, a stand has been taken by the authorities because this entire episode ended in 2009. Your certificates are of 2013. A stand has been taken by the authorities that you had never brought this to the notice of the authorities at any point of time prior to 2009. 16/10/2009 when the order was issued. What do you have to say on that? Show me. You have made an application on 31/7, right? 31/2007. That is not on record. Produce that application.
Lordship, if you go to the medical report,
Huh?
medical report.
Forget the medical report. We are on that day.
Yeah,
Show me your conduct on that day.
I have submitted all the documents
Where?
in the authority, your lordship.
Show me. 31/2007. Where is your statement? That 31/2007 letter by which half pay leave and your other leaves were granted to you. Therein you had categorically stated about your this mental ailment. Because on that day you did not have a mental ailment.
It is there, your lordship, if your lordship permit me,
Yes, why not? Show me. That's the only thing I want.
36/8/2006, if lordship permit me, annexure 6, starts from annexure 6.
Annexure 6.
Lord,
Page.
page 25 of my writ petition.
Okay. Okay, show me. This was on the basis of your mental ailment.
Lord,
Just show me that.
1 to 2007,
I know these 1 to 2007, there are around 4 orders.
they have granted. Now,
But show me, this was on the ground that you had mental ailment.
Lordship, my humble submission before this honorable court, I have filed my additional affidavit
I don't want that. I'm on this.
whereby there is a letter also, your Lordship.
You show me that as on this 1 to 2007,
Yes,
the authorities knew that you were having mental ailment.
it is there in my affidavit where the medical report says that in the affidavit of the medical board,
Forget the medical board is of 2017.
Lordship, there is a statement. The report which has been said in 2023 patients suffered from schizophrenia.
We are on 2006, 7, 8, 9. Show me.
The documents which I,
Because the document, that first document that you have annexed in the writ petition is 2013.
the original sum of the documents have already been placed before the authority, your Lordship. It is when there.
Where is your statement to that effect? Show me. That this 1 to 2007 episode of leave was granted to you because you had informed them with documents that you are suffering from mental ailment.
Yes.
Because your documents, you yourself say it's after 2008-9 you had this problem.
No, Lordship, that is not that.
Show me.
2003, my humble submission, I have mentioned before the,
2003 in the medical board report, it is there.
that is there.
2004 you were promoted.
Thereafter, 2006 onwards, I have been.
Show me that. Show me.
That documents, Lordship,
Show me your statement to that effect.
Lordship, I have mentioned in my additional affidavit.
You show me in your writ petition that this leave that was granted to you while these orders dated 1-2 was on the account of a statement made by you that you were suffering from mental illness. Only that much I want.
The documents which Lordship has permitted me to.
Statement.
I mentioned the some of the documents. I mentioned that the sum of the documents which I have.
In your writ petition,
Lordship, I have filed my additional affidavit.
you come to page 7, para 5. Because their categorical statement is till 2009 when the orders were passed, they never knew about your health. And you have not countered that anyway. That part of the statement, you have not countered. You want that statement?
Yes.
Yes. Come to their affidavit.
Paragraph 3, your Lordship, the affidavit filed by the authority, your Lordship.
Come to page 3,
Lordship.
just above paragraph 4, 7 lines. But
Here, whereby
the petitioner till the days of passing of the memorandum dated 16/12/2009 has never submitted any certificate either from the said so-and-so or so-and-so. It is therefore denied so-and-so. Now just clarify this one.
Lordship, in that stand, you also, we have mentioned that the documents which we have submitted before the authority by one assistant manager, his name is M.N. Sharma, your Lordship. Where it has been, I have been mentioned categorically, Lordship.
Show me that.
It is there. If Lordship permit me to go to the, I have shown paragraph 6, page 6, paragraph 6 of my additional affidavit.
It's not an additional affidavit, it's an affidavit in opposition.
Opposition, where the deponent stated.
Page.
Page 6, your Lordship, paragraph 6. Whether I have been submitting any documents in that relevant point of time, I have mentioned here, Your Lordship.
But why is this not mentioned in your writ petition?
Lordship, what is happened, all the things which I have got it, Your Lordship, I have done it. Rather than when the affidavit filed by we suppose that we will be retained by the this person is senior P and AO establishment to whip.
Okay. In your application for voluntary retirement in 2009, have you mentioned
Yes,
that mental ailment you have mentioned?
Yes, it
Where
is
is
there.
that? Where is that letter?
That record is in there.
Mr. Chakraborty, where are the
Record is also-
records?
Record is not with us.
Get the records. We'll have it on Saturday.
2011, 2009.
Saturday. This Saturday, get the records.
On Monday, next Monday.
Monday, okay, Monday, get the records.
Everything
And
is
I
there.
want a thing in your written statement, which I just read,
Yes.
you have categorically said till 16/12/2009.
Yes.
He had never approached you with regard problems of mental illness. Establish that. Get all his, and I want that application submitted by him on 30/1/2007.
And moreover, your lordship, they also categorically mentioned that it is, there is no provision for holding any inquiry under ONGC Review Rules 1995.
And why didn't you appear before the medical board? Twice they constituted a medical board. Why didn't you appear?
Lordship, what is happened, my treatment, my medical,
And Mr. Gogoi, subject to what the records reveal, what we find from the documents is, once that notice was given to you, prior to 16/12/2009, all these things started coming on record. That's the only doubt we have now. We'll have to clarify that. And if it is found that till that 16/12, you never approached them with this problem, that's the end.
Lordship, in that.
Only Saturday. Let the records come.
Let
Monday, my lord.
Monday, sorry, 22nd. On the prayer of Mr. Parties, list this matter again on 22/4/2024. Mr. S.K. Chakraborty Land Council for the respondent shall produce the record wherein the application submitted by the petitioner for leave and other, including the application dated 31/2007 and his application for voluntary retirement is available.
And all the applications which I have filed prior to the date here also. And diplomas.
Item 7.
None appears for the petitioner on the call. The petitioner, by way of instituting the present proceedings, has raised a grievance with regard to the action on the part of the respondent authorities in not releasing to her due family pension on account of the services rendered by her husband, late Kyla Linson, as a muster roll worker in the establishment of the respondent number 5. Also, as projected in the petition, the petitioner's husband, late Kyla Linson, was engaged as a muster roll labor in the establishment of the respondent number 5 on 1/8/1981. Also, while working in such capacity, the husband of the petitioner died in harness on 7/4/2005. After having rendered services for around 24 years, 8 months, 6 days. Also, it is the case of the petitioner that the services of the petitioner's husband, although liable to be regularized, the same was not so regularized, and before the process as initiated in this connection could be taken to its logical conclusion, the husband of the petitioner had died. Also, the petitioner has referred to similar cases instituted before this court wherein directions were issued for creation of a supernumerary post for 1 day for regularizing the workers as the husbands of the petitioners therein, and thereafter for releasing the due family pension benefits to the family of such employees. Also, 1 day regularization permissible. If you say yes, I'll yes. If you say no, I'll say no. No. Why? Where is my Lord Justice Ansari's order? Review petition.
Well, I don't have the copyright with me, right now with me, but I can bring it.
Can you get it?
I can get it.
Also,
Lordship.
the above issue had arisen before this court wherein in WPC number so and so, 14%.
Yes, Lord.
WPC number so and so, wherein this court had disposed of wide order dated so and so had disposed of the said the writ petition directing the respondents to create a supernumerary post for 1 day and thereafter to regularize the services of the husband of the petitioner therein. On such regularization being made, it was directed that the family of the employee, master role worker involved, be release their family pension. Also, the state of Assam being agreed by the said order had instituted review petition number so and so dash dash before this court, praying for review of the said order. Full stop. This court wide order dated so and so proceeded to dispose of the said, allow the said review petition, recalling the order passed in the writ petition and in the writ petition. Also, the relevant portion of the said order dated so and so is extracted here in the full stop. The present writ petition is squarely covered by the decision as contained in the order dated so and so, and the same would squarely apply to the facts of the present proceedings. Accordingly, the writ petition stands. Accordingly, following said order dated so and so, and review petition number so and so, the present writ petition stands dismissed.
Well, I'll submit it.
I think I have it. I'll also put it. If you get it, state had filed a review.
True.
And there are around 2-3 cases. Namgita University. None appears for the petition.
One and four.
For the respondents. You are appearing for?
AG, on behalf of Arcade Arunda, AG.
AG. You just write down your.
Lord.
Item 8.
Yes.
The petitioner is in the post of working in the post senior engineer assistant, which is a grade 8 post. But a circular was issued. That is at page 27. Criteria,
You applied.
I applied, but
They said that you will not be considered because that's a single
single
cadre
cadre
post,
post.
so they will not consider you. Subsequently, you were given a letter wherein it was said that you are now eligible for consideration.
No, I am not on that, my lord. Now, I asked them whether I was eligible at that time on 12, in 2012. They said they gave a reply. Thereafter, they said that there is a subsequent
Memorandum of settlement.
Now, your dispute before your lordship, in fact, the memorandum of understanding, as per memorandum of understanding, whether a single cadre person holding a single cadre post would not be entitled to appear in an interview for officer grade A post. That's the question. Moot question. If your lordship see that memorandum of settlement, that is cluster-based promotion. In between the cluster-based promotion, that policy deal with, not in respect of non-officers to officer cases. Am I? If your lordship have a look on the cluster-based promotion, their affidavit at page, your lordship kindly start from internal page 11, page 38.
Can come to page 39.
39, yes. These are the cluster, they formulated. And how the promotion will be among the cluster, my lord, your lordship kindly note it down, it is among the cluster. Now your lordship kindly turn to page 40 at page clause 2, down below. Has your logic got it?
Hmm.
Promotion within the cluster.
Hmm.
This is the promotion within the cluster, my lord.
Hmm.
Now your lordship kindly D, next page, at page 41.
Wherever salary.
Wherever salary grade 8 is not in existence in the cadre at present, the same grade will be provided so as to form a cluster C, comprising of salary grade 4, 6, 7, 8.
Hmm.
However, while affecting promotion, your lordship kindly
Page
notice.
43. Clause 4.
Yeah, clause
E.
4. Which one, my lord? B.
A and B.
A and B.
That is the issue.
Promotion
Employees
of
who are in
single
this-
cadre, this is the issue, according, they relied on this.
Hmm.
It relates to promotion within the cluster, my lord.
No, promotion for single cadre position.
Position, as mentioned in Annexure 3, will receive promotion within the cluster. my
Then
lord.
B.
B, those employee in single cadre position who reach the highest salary, grade A, B, will be given the next higher grade, so and so, on completion of 8 years. Such employee will not be governed by the policy of promotion within the cluster mentioned in item 2.
You mean to say this does not debar you
Ah,
from the promotion to the officer's cadre?
yes, it's clause 5 below. Look at the clause 5. Therefore, my lord, therefore circular never stipulated any condition. Am I clear to your lordship,
Yes.
my lord? At this memorandum of understanding only arrive at for promotion within the cluster, not the promotion to the, because otherwise, my lord, clause 4
Hmm.
will contra to the clause 2D, my lord. It can't be,
2D.
my lord. Am I
Yes.
clause 4, who is it? If the embargo for the non-officer to officer, then the clause 2D will be held, you know. If you compare the 2D and the clause 4B, look, that is why clause 5 will be.
Mr. Kotogi, you were initially recruited as grade.
Initially appointment, my lord. That I'm not problem is, my lord. Drafted by engaged brief, it is very difficult, my lord. You know, right? You know, right? Right.
Safety inspector grade 4.
Grade 4.
Grade 4.
Para 2.
So he reached, when this was there, he reached grade 8.
A.
Right, Mr. Deka? So how was this promotion from one cluster to the other given? Because 4 contemplates only a promotion within the cluster.
No, this came into force in 1992.
92.
92.
And his promotions were
Maybe earlier, man. That's not part of
safety officer grade 4, 1990.
1990. So when he got
So 92,
Must
he
have
came,
been-
he
must
came, no,
after
no, no.
92. It will be after 92.
It will be after 92
After
only.
92.
So it will be covered by this. Three years. So his first promotion will be after coming into force.
After coming.
So then, now tell me how he has gone from, so he is in grade 4. That means he is in cluster B.
B.
So how did he go to cluster A? If he is a single cadre post, because here in terms of 4B, he can be only given the special grade. Is there a direct recruitment to cluster A also? 1, 2, 3.
1, 2, 3 will be direct recruits only.
Direct recruits only. Okay. Then come to 4B. Mr. Kotogi, 2 minutes. Let me just have that. Those employees in single cadre position and who reach the highest salary grade within A or B will be given the next higher salary grade as special grade on completion so and so. Such employees will not be governed by the policy for promotion within the cluster mentioned at item 2.
Yes.
So how did he come to cluster A?
He joined as safety inspector grade 4. Now, whether
Grade
that-
4. Now you
now
come
whether
to
that
your,
that is a single cadre position or not.
that is an annexure 3.
That is not a single cadre post. Single cadre post is safety inspector, grade
Safety
7.
and inspector, that is
Grade
grade 7. Okay.
So when he reached that
So how did
particular-
he,
when he reached that grade 7, my lord, it becomes a single cadre post.
Okay, so he is in cluster C, that means,
He is in cluster C, that means.
huh?
He is in cluster C.
So how did he get to B and A?
No, my lord, C is higher.
Oh, C is higher.
C is higher. 1 is the lowest, my lord. 8 is the highest. From 8, he
Okay.
goes to officer's level.
Okay, okay. Okay, C. Okay,
So as per annexure 3, my lord, it is safety inspector is grade 7 is single cadre, not grade 4.
okay. And now if you come back to that notice,
27, page 27.
page,
That's circular,
circular,
27.
seven and 8. Okay. Now show me the bar.
That is the part the lordship has read already. my lord. Because if the single cadre positions are held at to be par at the other with the others, my lord, there's no point in having clause number 4, my lord. Because if your lordship holds, lordship interprets that the persons having single cadre are at par with the others, my lord. There's no point in having clause 4 or single cadre position.
And this is under section 18 of the
Section
ID.
18. But these are not.
Now,
our
show me
policy.
the change that you have brought down.
Change
Not
is-
understood that.
These are actually all part of negotiations, my lord.
I know that, but what is the change now?
Page 109.
Hmm.
6. All single cadre positions will cease to exist.
Hmm.
All workmen of cluster A, erstwhile single cadre of cluster A and erstwhile single cadre of cluster B and parallel channels for the purpose of career progression will be categorized as follows. All workmen eligible for parallel channel and stagnation relief. Matriculates and above eligible for placement on selection to higher grades.
This is the question Mr. Kotoki is most probably trying to raise. Now, if you come back to your that earlier policy, page 39 is the cluster
My lord.
A, B. Right?
Right.
Now, 2 D.
Then lordship will also have to read page 110, the clause number 7, which is because man, he wants promotion from officers category to, I mean, the.
Officer
non-officer
grade A
to
category.
grade A. Now the question is, he has already retired, my lord. So it will only be giving promotion and
Monetary benefits.
only monetary benefits. So clause 7 will now come, my lord, so
Hmm.
far as he is concerned now.
Hmm.
That is, of course, if your lordship holds that he was not eligible. If your lordship holds that he was not eligible in 2012, then my lord, he does not get any relief. Because from 17, when this amended memorandum came into force, my lord, there has been not been any promotion.
Because your statement, categorical statement is after that there was no
There
vacancy.
is no vacancy.
Now, Shay, what do you want to say about 7?
No, 7 is now he comes within 7, my lord.
But this, he will not get it because there is no,
There is no
so no
vacancy.
point in going into
No point
this.
in going in.
So we'll only have to consider
Yes,
whether
Lordship will only have to interpret clause
12.
4, my lord.
clause 4.
Clause 4.
Now come to 2D, page 41.
Yes. Wherever salary grade 8 is not in existence in a cadre at present, the same grade will be provided so as to form cluster C comprising of salary grade 6, 7 and 8 in all cadres. However, while effecting promotions from non-officers category to officer category, wherever salary grade 8 has been provided, as mentioned above in a cadre, all the eligible employees in salary grades 8, 7 and 8 will be considered together.
Now, 7, he is already there.
Is there?
So there is no bar for his consideration. The bar is A, B and C.
No, otherwise D is not a bar for him. If 4 is not there.
Now come back to 4.
Yes.
So 2D, we understand everybody is.
Everybody is in under 2.
Now you come to 4A.
4A. Employees who are in the single cadre positions as mentioned in Annexure 3 will receive promotions within the cluster as per the promotion policy.
Fine.
Within the cluster mentioned in item 2 above.
Hmm.
So from 2 above,
So if somebody is in A, single cadre, he will come within the grades in A only. If
Right.
he is in B, he will go within the
Within
cadres in B.
B.
C is not touched here.
so see if he is in grade 5 or 6 in C,
No, here if you come to 4A and B, C is not touched. Cluster C is not there.
in B it is not there.
Now you come
is
to
B in
B.
top.
B. Those employees in single cadre position and who reach the highest salary grade within cluster A and B will be given the next highest salary grade as special grade on completion of 8 years in the existing grade.
Right.
Such employees will not be governed by the policy for promotion within the cluster mentioned in item 2 above. Mr. Dekka, is it right to hold that this does not envisage a promotion from non-officer to officer? It only envisages promotion within a cluster.
No, but he is not in A and B, my lord. He is in
He is
C.
in C, so he
so-
is not even covered.
So C, A will come, my lord. Clause 2 A will, 4A will come, my lord.
Employees who are in a single cadre position
As mentioned
mentioned
in Annexure 3.
will receive promotion within
Only
the
within
cluster.
cluster.
Fine, no
That is how it has
issue.
been interpreted, my lord.
No issue.
My lord.
Because you say, if you are in 7
Right,
and you are in 8,
right.
you are entitled to be considered as per your circular. 7 and 8, page 27.
Okay.
27 of the writ petition.
Yes, 27 will have to be read with the memorandum.
No. Why did you mention 7?
Because
You
7
did
is-
not say there that single cadre post will be excluded. And 4D does not exclude non-officers.
This is a circular notifying the vacancies.
Fine, forget that circular. 4A and B
Right.
does not exclude. It
Where
is
is
only
the-
an exception to
No.
2D.
No, if it does not exclude, my lord, then the 4 is left redundant, my lord.
No, it is not. Because persons who are there in A and B, single
Yes.
cadre post,
Yes.
in the event they reach the highest grade there, then they will be given a special grade. C, he is not even covered by 4A and B because he is already in C.
No, then A will come, my lord. A is not pertaining to
Employees
A
who
and
are
B.
in single cadre positions and mentioned in
As
so and
mentioned
so.
in Annexure 3, because his position is mentioned in Annexure 3.
No, will receive promotion. It is a beneficial clause.
Yes, he will receive only promotions within the cluster,
No.
not to the officer
No.
grade.
The problem is, if this provision was not there, he would not receive any promotion within the cluster also.
No,
Because
he will
there is
be-
no promotional post for
No,
him.
no, if this clause is not there, then
Hmm.
he'll come under 2, my lord. Two is there. 2 is for promotion within the cluster.
Okay, 2D.
2D he will come. If this is
2D,
not
then
there.
it says 7 and 8 are qualified for promotion.
No, he is entitled to promotion only within the cluster.
No.
2D is from class.
No.
2D.
2D again
Yes.
clarifies. Third line, however, while effecting promotion from so and so to so and so, where salary grade 8 has been provided as mentioned above in a cadre, all the employees in salary grade 7 and 8 will be considered together.
But then 2D has to be read with 5, my lord, not 4.
5, Promotion
Five is
from so and
promotion
so.
from, non-officer to officers cadre. What I'm submitting, my lord,
Okay,
if suppose lordship says that 4 is not there, the 2 covers everything, my lord. What was the
let us
purpose of
say,
adding 4?
no, that's what I'm trying to understand from you. What is the purpose of incorporating 2D and 4?
Right.
Tentative, my opinion is that 4 is on a different context altogether. It says A and B, single cadre post. If you are there, you reach the highest of that post because you don't have a promotional avenue, you will be given the special grade to that extent. Non-officers to officers, 2D. It does not distinguish between a single cadre post and a promotional, having a promotional avenue.
Right.
Now, these both are again subject to 5. That means you must have a vacancy.
No, that is there. 5 is, I am not on 5.
Hmm.
What I am on is 4A, my lord. Now, if what lordship is saying, if that is there, my lord, 4A is left redundant. What is the purpose of adding 4A, my lord? Because under 2, everyone is entitled to promotion within the cluster. What is the purpose of saying that employees who are in the single cadre as mentioned in Annexure 3 as per the promotion within the cluster mentioned in item 2 above? Single cadre positions, my lord, will be entitled to promotions only within the cluster. Appears to be
No,
harsh, my lord.
this is a
Why not?
clarification. This is a clarification for it. You come to 2A.
My lord. Yes.
Within the overall policy, employees will receive promotion from one salary grade,
Hmm.
that is within the cluster,
Within the cluster.
to the next higher salary grade within the cluster in a period of 4 to 8 years.
Yes.
Right?
Yes. Right.
Employees securing a minimum of 55 marks in terms of norms laid down in so and so will be promoted to the next higher salary grade within the cluster subject to the employee having completed. Where within the above policy does not secure so and so is not.
May I submit my opinion?
Yes.
2 provides for promotion within the cluster as well as from the class from non-officer to officer grade. But 4A clarifies that whoever is in a single cadre position will get only promotions within the cluster as per 2 above. Let us read 4 again, Manoj. 4A. Employees who are in the single cadre positions as mentioned in Annexure 3 will receive promotions within the cluster. My
That means from
responsibility
one grade
limits.
pay to the another grade.
Yes.
Hmm.
As per the promotion policy for promotions within the cluster mentioned in item 2 above.
2 above.
It does not say that you will get promotion from non-officer to category A officer also.
Need not, because that is covered by 2D.
No, here it limits, madam.
Because
Limits it, madam.
Mr. Deka, how are these promotions from grade to grade done? Say somebody, if you come to cluster A,
Right.
cluster B, operator. If
Cluster
you come to
B.
A, operator, cluster B, page 46,
No. See, 40,
Annexure 1.
46, yes.
These are the posts you have.
Here.
So within grade 4, you have this number of posts.
Yes.
Grade 5, same posts,
Same post. Name is nomenclature is the same.
same. Then it changes in 6, grade 6, operator. So, and that is also same.
The designation is the same more or less. It is only the salary grade.
Okay. So it is not like, say, LDA, he'll be promoted to UDA. Statistical assistant does not have a promotion to UDA, say. So it's a ex-cadre post or a single cadre post. Now for them, the promotional avenues are prescribed. Here it is not prescribed. So when he became a safety officer, he occupied Annexure 3,
Page 52.
page 52. So this safety inspector is not there in grade
No, it is not that.
Four.
It is fire operator, my lord.
Fire,
Firefighting operator.
firefighting operator. So firefighting operator is not a isolated cadre.
No.
So he was a firefighting operator.
If he was a firefighting operator, he will get it, my lord.
Trying to understand. He was a firefighting operator. He became a safety inspector.
He cannot,
He was recruited as grade 7
my lord, he was recruited as a safety inspector grade 4
directly.
directly. That is para 2 of the reputation. Safety inspector grade 4 at the top, my lord, page 5. Second line.
Okay. So from 1990, he is stagnating there.
He is safety inspector grade 4. From grade 4, he has reached grade 7, my lord, grade 8 in the same paragraph, my lord.
Now show me that post where it is in grade 4.
My lord, in 1990, this was not there. This came in 1992.
Huh.
So in 1990, what was there, my lord, that we'll have to find out.
Just find that out.
I can find that out.
Because if he is being like this operator thing, operator, right along till grade 8, it is operator.
It is up.
Now, if there is a firefighting officer, earlier, what was the position? If he was a security, what is that? Safety officer,
He was a safety officer,
safety officer, safety inspector,
safety inspector.
safety inspector. So grade 4. So that grade is going like before under your earlier settlement, 4 to 5, 5 to 6, 6 to 7. So if that be so, he is similarly placed like the other people.
Provided it is there, ma'am.
That's what you have to show. Because I don't find anything like
No,
that.
it is not there. Subsequent to that 1992, it is not there.
Not there. Forget 92. See 1990.
I'll have to find out.
How did he reach 7?
How did it accept?
When did you reach 7, Mr.
That is not.
That is, well, he says it is 2007.
Hmm.
Since
2007,
2007, he's saying.
I think there is a
2007,
reference in your affidavit. And tell me,
I'll try and get his personal file.
don't show us to, you
No, at
understand,
least- at
you
least
understand,
my
then let
understanding.
us, because this is something confusing me.
No, it
If
is
that
confusing.
post
It
is there,
confusing.
if that post is there, then his argument with regard to 2D will hold it.
Yes,
And tell me
Correct.
one more thing. He has made a further argument, further submission, that somebody was promoted in BRP.
that man, learned friend is appearing, my lord, that is not correct.
Yes. Who are you? Mr. Haloy, you were,
9 minutes.
I know that. Who are you? How were you recruited?
That part I cannot submit.
Because you have not filed a reply here.
He has not filed.
And I sent the notice also, he did not turn up.
Okay, fine, then forget
Until I
it.
see
Mr. Deka,
My lord.
that contention is there in paragraph in that IA that was filed for impleading
His
response number 9.
reputation was on a different line.
Different line. That is not the prayer also.
That is not the prayer also.
I thought that is the prayer.
That is not the,
Whole synopsis is on that line,
that is not the prayer. Reputation was on a different line, that why he was given
that incentive.
incentives. He got considered it to be a.
I
punishment.
was going on the incentive, then luckily I saw the prayer. It was on a different footing altogether.
Yes, yes.
And Mr.
But
Kotogi
we-
has
we
given the
will not-
clarification
I
and
mean,
what a
sorry,
transfer.
Milord. I had, you also had the experience that engaged people.
Can't help it. Now, respondent number 9,
See, DK Soikiani.
Mr. Deka.
My lord will kindly turn to page 97, my lord.
Hmm.
I think this is the, it's Dilip Kumar. This is of someone else, my lord. DK Soikia. He is also not a party.
No. Deepak Kumar Soikia is the
This is the
petitioner.
promotion order, my lord.
Page?
Page 97.
Oh, I missed that. No, this is his promotion.
His promotion. 17/2002.
Promoted as fire and safety operator. Fire and safety operator grade 7 has been promoted as fire and safety operator grade 8.
No, my lord.
In the-
This is safety inspector, grade 6.
No, there is another promotion.
Lordship is reading page annexure B. Here it comes fire and safety operator.
So
Just. Safety inspector.
he's gone up to 8 now.
So I'll have to clarify because from safety inspector grade 6.
He has become a fire and safety
how he has
operator.
become- This I'll have to clarify.
You just take it. And
Oh.
tell me about that respondent number 9 also. Because if respondent number 9, take one some. I have asked. Dilip Kumar Borua,
Dilip Kumar.
Fire and Safety Officer, Bongaigaon Refinery Petrochemicals Limited. And the statement is,
He has been appointed as fire and safety officer. Para 3.
there is nothing here as to what was his antecedent.
No, nothing.
You get that?
I'll get it.
Mr. Soika, Kakoti, let him have that. When?
Next week, madam, because it's another refinery.
25?
Yes.
25. On the prayer of Mr. N. Dekar, Learned Standing Council.
Not standing.
Oh, no. Learned Council appearing for the Oil India Limited.
Indian Oil Corporation.
Huh?
Indian Oil Corporation.
Indian IOC Limited. This will always confuse me. IOC Oil and ONGC Limited. This matter again on 25/4/2024. Also, Mr. Teka, with amongst others, shall also receive instructions as to the service particulars of the respondent number 9 herein, who was promoted to grade A officer from the post of fire.
No,
Promoted to grade A liquid for subsequent 25th.
which was chemical is started.
No.
It'll come again on top of the list.
Top of the list. Just get that. Otherwise, 2A, I think we'll have to interpret in his way. Can't help it. 4A is a clarification, subject to correction.
Item 10,
Not by me. List this before any other bench without me. Move nam to liquidity process.
item 11,
Yes, Mr. Korogi.
Yes, my lord, regarding my lord, they have challenged the promotion of the respondents, private respondents.
Hmm.
They were, they promoted, my lord. They were given exemption to the, without appearing in the.
Their case against you is that you don't have that grade 1.
Grade 1. They also don't have the grade 1, but they were.
But they were given the relaxation on the ground that they were BSc, computer programming,
Yes.
programming, and they had taken the leave of the or the relaxation by the Director General.
I like it.
What do you have to say on that?
No, actually, but that way, because they were not belong to the.
You were subsequently promoted as SI
subsequently.
because there was a general relaxation.
Relaxation.
What more? What more?
But I got proper notion of promotion, my lord.
Huh?
We retrospective, right?
No, because you don't have you have a BA.
No, not because of the qualification, because he was appointed SI.
No.
Your lordship, I see that cadre was not a computer operator, is not a SI.
But they have brought in that Assam police regulations and said that no.
That regulation was not in effect at that point of time. The regulation, but the service rules were not in force at that time.
No, they had a draft service rule. Draft service rule, and then they have brought in the Assam police rules.
My lord. But even then, my lord, but they are not qualified because that is not an essential requirement for a post of SI. They were computer operator. Your lordship may kindly see.
No, this is used only for the purpose of relaxation.
Yes, I understand, madam, but.
So
whether
that, show me whether you are also entitled to
But
the
whether the
similar
criteria
recognition.
that has been
Huh?
taken into consideration
Huh?
for purpose of relaxation, the criteria. That
Relaxation
criteria,
power until and unless you don't allege malafide.
I was said that because they are the blue-eyed boys, they are of the higher appearance, because he was working under the Director General of Police at that point of time. And
See, one of those promotions is of 97.
they were given effect to retrospective.
Be that as you know, that is 97 promotion. Respond number 6 or 7 is 97.
I promoted as a 2012-97.
And you have made this challenge in 2013.
13
In between, there is a proceeding before this court.
Yes, there was a proceeding was pending. There was a stay order also.
And 2009, respond number 6 became the inspector.
Inspector.
And you, at the earliest you approached this court, maybe sometime in 2011. Huh?
On 11.
11. After 2 years. By that time, things are settled up.
Basically, my grievance is with the SLAC for the S105.
We have seen it. And see, you were given chance to appear for grade 1. 3 chances. You did not avail.
I understand, my lord, but since the exemption was given to them, where under criteria that has been taken for consideration, my humble submission is that not this discriminatory attitude out of their blue-eyed boys, my lord, they are given favoritism, my lord. Because they are technical persons, but
You have not brought on record any of the officers whom you have alleged to be acting in their favor by name.
malafide,
Even
law, my lord.
direct malafide is also not there.
Malafide in facts is not there, but
Law also. Malice in law is also not being pleaded in that manner.
because here because of the highness of the Director General of Police, my lord, he has been accommodated.
You should have made him a party by name.
No, Lord.
Because he was working there at that point of time. He could not be accommodated in the police service.
Because say two pleas that they have taken, you have not dealt with that. This was a post which we were in need of. And we have the power to create that post.
So actually, it's the computer operator is not a career post.
See, rather your statement in the writ petition is that both of you are similarly situated. So, computer programming, they wanted a person, they appointed him. And then that relaxation was given.
Okay.
How can you, when
But
the power
career
is,
post, but they have to create a career file for computer different, but why you are mixing with some assignment?
that is not your pleading. Rather, your pleading is we are all one.
Because I have not drafted, I understand. I have to make it.
That's the pleading.
Because he was accommodated because actually there in the computer.
Your categorical pleading is that we are all one.
And that post was created for
And
the
you have even made a statement somewhere that these are not ex-cadre posts. These are cadre posts.
because it was not in a career. Computer operator was never in a career. To accommodate him, he was brought in as an assignment. Otherwise, would not have get a regular service.
What is your prayer?
Prayer is for promotion with a retrospective effect, my lord, that you all will find.
23 lots. Yes.
Base 23, my lord.
So 2013, you are asking for a promotion from 97.
97, my lord.
And you retired as a sub-inspector.
I'm retired.
Not a fitness. Because that exercise of power, you have not twisted. They can. Only vague.
Again,
Sorry,
the,
Mr. Kotogi, not in this case.
again, the authority also, my hands are tied. I cannot go. That
Police
yes, my lord. No.
dismissed.
Or maybe as a matter of infrastructure, that can be.
Huh?
Because he already retired from service, my lord.
If you make that prayer, it will be
Yeah,
his.
that will be.
Mr. P. Kotoki, Learned Counsel for the petitioner, submits that the petitioner has, in the meanwhile, during the pendency of the present proceedings, promoted to the rank of sub-inspector, APRO, APRO, and has thereafter retired from his services on reaching the age of superannuation. Accordingly, Mr. Kotogi prays that the petitioner is not interested to pursue the matter, accordingly, the same may be closed. Post of prayer accepted, the writ petition stands dismissed on withdrawal.
Item 12.
Have you changed side,
No,
Mr.
Lord.
Sharma? Because
I
your
mean,
name appears in both sides. Why?
I do not understand
This
how,
is not a good thing.
but I think that is a different issue, not me.
No, this is the same issue.
No, I have also checked up because 2013, I
Oh.
checked up. It's not me. That was the first thing I did.
Apparently, but you can't appear from both sides.
That was the first thing I did. I just checked up. Was it me or
Yes, who is appearing for the petitioner?
otherwise 2013 selection process, 24.
I have been
Now tell me one thing,
Yes, Lord.
all said and done. Is this your policy? That annexure? That constitution of the selection committee,
Yes, Lord. That is at page
91. Internal page 18.
running page is 91, otherwise it's page
18.
Yes, 91. Yes, Lord.
Now, is this for this selection or is this the norm?
This was the norm at that point of time, as per my instructions. But now, pursuant to the
Maybe
judgments,
you
it
have
has
changed
changed. It has changed.
But every selection, because in a paragraph you have said in page 86, that last 5 years, very intelligently drafted. It is further submitted that so and so through this procedure during the last 5 years. So do you mean to say that this apportion of marks and the cutoff marks is the norm in the company?
If
Is
this-
it the norm?
If this is the stand in the affidavit, I have to.
No,
provide this.
no. You are the author of the affidavit, so you should tell me.
No, but then now it is on record, so I cannot have.
That is
multiple-
on record, that
Yes,
is a vague
it is,
statement.
it is otherwise.
Just tell me if this is the cutoff marks, not only for this selection, but for all. I'm closing the writ petition as dismissed for default.
It
Otherwise, I'm interfering.
Yes, it otherwise.
Yes.
Pardon, Lordship.
Huh,
it was,
Huh.
On the way, Lordship, the leading counsel of this matter is on the way to
Oh,
his.
no problem. We'll have it after some time. Let him come.
Actually, Lordship. Can it be password for the day, Lordship?
No.
He's,
No.
Like, tomorrow there is,
No. Today itself.
Lordship, he
Today
is on the way to home, Tinsukia, Lordship.
We are not, we are least bordered.
He-
We are
he-
least bordered. We are
He
least
has to
bordered.
cast the vote, Lordship. Tomorrow there is going to be
No.
election, Lordship.
Think that he had left for Tinsukia.
Yes, Lordship. He's on
He
the
said
way.
he's coming.
No, he's
He's
on the
left.
way to
What is
Tinsukia,
right?
Lordship.
Then how will he come tomorrow?
Now tomorrow there is election. He is going to his hometown, Lordship, for casting vote, Lordship.
Oh, vote.
So, yes,
Saturday. We'll have it on Saturday.
Can it be on Monday, Lord?
Monday.
Monday.
Client is still interested.
Yes, Lordship.
Very interested.
Yes, Lordship.
Who is your leading counsel?
Leading counsel is M. Das Gupta, Lordship.
M.
Das Gupta, Lordship.
On the prayer made on behalf of Mr. M. Das Gupta, who reportedly has proceeded to his hometown for casting votes in the ensuing general elections. List this matter again on 22/4/2024 as a part of it.
In the meantime, I'll take specific instruction on paragraph 26. I'll do that.
If you tell me that or demonstrate that although we had not disclosed this to the candidates, it was taken in June, May,
Yes,
and the selections were from June.
June, yes.
We have not disclosed. Fine, no issue. But this is the norm and this is the cutoff marks for the Viva. This is the cutoff marks for the group discussion. In all selections and as a part of policy, we follow it. That's the end of the matter.
Probably that will be the start because.
But
oil
you
is
will have to
otherwise-
show me something.
That
Yes.
period of,
Yes, that period of.
Huh?
time.
at that period.
Huh?
At that
At the
period of.
At that period of time, I don't want
Now the policy.
that period of time and that paragraph which you have said. You have said many things, but you have not said anything there. So clarify this
Yes,
too.
I'll do that.
We will not entertain this. But Mr. Sharma, if that is not there, then that whole line of judgments, Rahire, Himani, everything will fall on you. I'm not on the percentage apportion. That in this case cannot be. The 50%, it's around 33% if we take the interview component.
Lordship is on the aspect of changing the rules of the game.
Changing the rules
But
of
then
the
again, that probably will not come in the picture because here, before the Viva or the written test should have taken place, we have
No.
got this guideline.
that is not disclosed in your advertisement. And this is something which you took just before the recruitment process.
But whether it was a universal policy that we follow.
If it is a universal
I-
policy,
I
done.
get the message. Obliged.
Deeply obliged.
Item 13.
May I please, your lordship, I am appearing on behalf of P.K. Burman. He is suffering from fever, my lord. So
on the
maternity
prayer
accident-
made on behalf of Mr. P.K. Burman, Learned Council, appearing for the petitioner, list this matter again on,
After a week, no more.
what happened to sir? Fine,
Yes, he is suffering from thyroid fever.
viral fever, 10 days. 10 days only. Thirty-four, 2020.
Deeply obliged.
Nothing to be done here. We'll only have to follow that Upendas and
Yes, sir.
dispose of the matter. Tell sir.
Deeply obliged.
14.
Please, your lordship.
What do you want now? The money.
The medical report.
Yes, why don't you pay him?
Lordship, our simple stand was there.
Your simple stand, not a simple stand, it's a very complicated stand.
That is the stand of ATCL is
The
lack of referral. That is the stand.
Forget it. Referral is down. Other things have taken over. You are not denying that the person was not suffering.
That was not denied. Lordship.
Huh?
That was not denied.
Then
But they have shown the technicalities
technicalities,
and stand.
when it is that factum is correct, why this technicalities? Pay. If you pay, we will not impose interest. If we have to do, we'll impose interest. Choice is yours.
Regarding the payment also, at least I have to take one instruction also.
2 o'clock.
They,
2 o'clock.
uh,
You pay him, tell them, you pay him, we are not imposing any interest. We'll ask Mr. Nair to accept whatever he is getting. But if we have to direct for that payment, 9% from the date it was due.
Lordship, at least 1 week time may be granted, Lordship.
Huh?
1 week time may be.
No,
granted.
no. Maximum 24th.
24.
Hmm.
Yes, Lordship. I have to take
And
instruction.
with this stipulation, if you are not paying, we are directing for interest. And we'll give our reasons for that. Mr. Das, use your office, good office. Genuine case. If you had disputed that, we would have, I've tried to scan it. I scanned it to find a dispute being raised. The only thing, no referral. But you have not disputed the factum of that ailment. And he was your employee. He's entitled to that. Whatever he is entitled.
Because
They have claimed around 40 lakhs. We are not saying.
no, 40 lakhs.
And subsequently, there is a certificate from the government also.
My lord, 9 lakhs something from.
9 lakhs.
As payable.
That was only. As certified by the director of,
By the government.
by the government, I think it's by the director.
The director has written,
And-
director had written that since there was no referral,
Uh.
my lord, their affidavit, my lord, page, my lord, the last annexure,
Hmm.
the second last annexure. My, I copy, there is no page initial, my lord, but the second last annexure, 26 July 2011, my lord.
Affidavit by
Affidavit by the ATC, my lord.
dated 26/4
My lord,
by Dipur Hara Prasad.
yes, my lord.
But our Chinese will pay a pay to buy affidavit note. Page number.
Yes,
This is the one. This is the one I was.
my lord.
I'm director of so and so, so and so, so and so, so and so, has no objection to the payment of admissible amount. So and so only as directed by so and so, so and so, only this amount you pay.
Lordship, without imposing any cost, possibly first appropriate order.
No, no. Will impose cost. Because you went up to the government clear, this shows that the factum of the illness, ailment is true. Referral, that we will handle, don't worry. Or are you disputing this? You have not disputed this.
Only stand is referral
Referral
and
is not.
respect to approval was not given by the Director of Health Services.
That is only
Only
a procedural error.
because we have followed only the
Well, in fact, the 2008 rules, my lord, provide that if it is referred by the medical college, my lord, then there is no need for a referral.
Referral. And he is referred by the medical college.
Assam
Sorry,
Medical College.
Assam Medical College.
So I'll take the instruction also, but it may be fixed on 24. Lordship.
Oh. Do you know why? Because of the materials that are available on record. The harassment that you have subjected this lady to. Right from. We are not going into that.
No, Lordship,
Maybe.
is true, but one thing is
Maybe
that-
she has also contributed.
One thing is that
Maybe she has also contributed on the advice of Mr. Nair. Maybe. But that harassment is there. And at least this much she is entitled. You just make a phone call.
Yeah, Lordship.
On 24th, we'll pass orders.
24th Lordship may fix, I'll take the instruction.
If you say that you are not in a position to do anything, we will close it today only. We'll pass orders, 9% from the date, 9 lakhs.
Yes.
Simple, 2 pages of.
Financial situation of HCL is
I
not
with that, you sell some tea, more tea.
the stand of the HCL Lordship, my humble submission before Lordship, stand of the HCL was as per a provision of law. Because
Provision of law,
Essential-
government has cleared it. In 2000,
the government has, Lordship, our application
2011, what prevented you for the last 12 years,
in
13 years to keep it in abeyance? 40 lakhs to 9 lakhs, still not paid.
the 40 lakhs including.
And where is that provision of law? 2008. No need, we'll
40
close
lakhs
it today.
including is a year salary. We have paid.
Hmm?
40 lakhs inclusive, 40 lakhs is not a bill.
No, 9 lakhs only. We are not going into any other grievance.
Or 4H2. The highlighted portion.
Where is that?
My lord, it's by the registrar in my affidavit, my lord. Page 10 of my affidavit,
Reply.
of my reply, my lord. It is by the registrar of that. Annexure K.
But this is by the registrar,
By the,
not by the head of the department.
yes, ma'am. Not by the head of the department, but by the registrar. Alright, here it says the senior most doctor, my lord, in the medical colleges, it's the registrar who issues the certificates, my lord. Senior most medical officer, my lord.
So this 9 lakhs is after recommendation of the director of,
My lord. Accepted by the government.
and this is a government company.
Yes, my lord.
Mister, 9%. We'll have to compensate. Today, 9 lakhs is nothing. That time, 9 lakhs was much. How much interest? From the range from 9 to 12, how much? 9%. Disposed of 9%.
Deeply obliged.
And Mr. Nair, we are recording your statement
Ma'am.
that this is the only grievance you are.
My lord, in fact, I had taken a email from the petitioner. Yes, earlier I was not handling the matter.
Your statement is
Ma'am.
enough for us.
Lordship, that is to my statement, that is stand of the ATCL in paragraph 8 of our affidavit opposition, that may be recorded, Lordship.
Paragraph,
Paragraph 8 of the affidavit in opposition.
wait.
In page 8, Lordship.
Okay.
Obliged.
Deeply obliged.
Anybody else appearing? Mr. Das, you are appearing for respondents?
2 and 3.
2 and 3. And anybody?
Paying for each of it is.
ACB, my lord, it was for the electricity connection. That one.
Anyway.
My lord, my lord, my lord.
So respondent number 1, Ms. Borman, Madam Borman. Two and 3, Mr. Das. 2, 3, 4 also, 5 also. All under you.
Yes, Lord.
5, 6,
Six,
7, 8.
It was by name, my lord.
Forget
8, 9,
7,
and 10.
4 to 1, 2 to
9
7.
died, Lordship.
Huh?
9 died, Nityananda
No,
Gupdeva.
no, we are not there. 8, 9, 10, we are not interested. And Mr. Your name?
Because
Huh?
W. Ahmed.
Abdul Ahmed.
W.
Ahmed. You are for the ASB. 11 and 12.
On behalf of each.
Hmm?
On behalf of each.
You are?
everything.
Will pass out.
My lord, deeply obliged.
It'll be tough for you. Yeah.
Item 15.
That is lost.
Hmm.
My lord, this case, my lord, the punishment imposed, lordship, that is not prescribed under, my lord, CRPF rules, my lord, rule 27, lordship.
Okay.
My lord,
Show me.
cumulative effect, lordship,
Show me.
my lord, page 25, 65. Lords.
The reduction
Yes,
of pay.
lord, yes.
It
That is
put
not
us
as per law.
a CRP effect.
CRPF rules to 27 laws.
More does it mean? CRP effect. Yep, 9 CRP effect.
My lord,
You have a book.
Yes,
It will
yes.
deliver. It will have. But you have not pleaded that. Have you pleaded that point?
yes, laws.
There is a pleading to that effect.
Yes, lord, not there. Yes. Now, one is dismissal from service, dismissal or removal. With-
Come to 3.
My lord,
Come
yes,
to 3.
yes, lordship, G.
Reduction to a lower stage in the time scale of pay for a specified period.
Specified period, no cumulative effect, lordship. My lord, that too, my lord, the order, lordship, two part of, my lord, punishments, lordship. That will affect the increments, my lord, these are increments, lordship. This is different punishment, lordship. That is not prescribed under Rule 27.
Where is the act?
Page 65, can you see, Lordship? One part of my grievance. Clause 8, Lordship, highlighted, Lordship. And the reduction of pay by 2 stages in time scale of pay in the revised pay scale of corresponding pay scale of rupees so and so for a period of 3 years with cumulative effect. Reduction of pay by 2 stages will be effective after fixation of his pay. He will not earn increments during the period of reduction, and that on expiry of such period, the reduction will have the effect of postponing the future increments of pay. This is different punishment, Lordship. My Lord, Honorable Supreme Court's, my Lord, court in my Lord, various judgments have, my Lord, repeatedly, my Lord, postponed that the punishment should not be imposed, that is not prescribed under law. Well, one is 2012 5 HCC 242. This is a Vijay Singh Lordship. Vijay Singh versus State of Uttar Pradesh. Other is Lordship. This is our Honorable High Court judgment. This is Rahul Kumar. In this
Rahul
case,
Kumar, yes.
yes, Vijay Singh judgment was relied upon, Lordship.
Majumdar's argument.
My Lord, another was, my Lord, 2011 2 HCC 212 paragraph 16. My specific Lordship proposition of law, Lordship.
So, Mr. Ahmed, your only grievance is to that extent.
That is one of the grievances, Lordship. Other grievance, Lordship. Kindly see the judgment of the Honorable High Court, Lordship.
Yes.
My Lord, the Honorable High Court, my Lord, earlier, my Lord, set aside the, my Lord, the.
But it culled out a part of the charge which it held to be proved.
My, yes, Lordship. My Lord,
So,
one was, my Lord,
show me a law
my Lord,
that you are entitled to back wages
back wages.
automatically
My-
under such.
My Lord, it is not a case by the no pay, no work, Lordship. It is not the case of the principle no pay, no work, Lordship. My Lord, the Honorable High Court, my Lord, set
No, no,
aside
no.
the.
It's not a case of no work, no pay. It's a case of a misconduct being proved. You're
Yes.
not entitled to that. Pay.
My Lord, what I'm submitting,
There is
once,
somebody sitting behind
my,
you
once the
reading,
judgment
who is
was
very
set,
much interested in this
my,
line. Who
my,
always
once the
confuses
punishment
me.
was
with
set
this.
aside, Lordship.
Huh?
Once the punishment was set aside, Lordship.
Punishment was set aside with a stipulation that they are to pass another punishment order
Yes,
on you
Lordship.
by highlighting the misconduct, and a beautifully written judgment.
My Lord, one misconduct was,
The
my Lord,
beauty of that judgment is that it pulls out the portion which is bad
the Honorable Division
and
Bench.
then exonerates you from everything else.
My Lord, what is there, Lordship? After, my Lord, setting aside this that punishment, Lordship, I approached the authority. I submitted the judgment of the Honorable High Court, my Lord, single bench,
They
Lordship.
went up to
Then,
division
my Lord,
bench.
after 1 year, my Lord, to avoid contempt, Lordship, So I got contempt file, my lord, writ petition, writ lordship.
Hmm.
In the writ bill, my lord, that judgment was not, my lord, stayed.
Yes, Mr. Adhikari, what do you say?
My lord, so where is that?
Penalty not prescribed, imposed.
Yes, madam. Now, my lord, for that, my lord, I take a lordship to rule 102. For CRPF rules, my lord.
102.
Yes, on the
Ah.
CRPF rules, my lord, yeah, where, my lord, the
Ah.
applicability of central government rules and orders is mentioned, madam.
Hmm.
So, my lord, the cumulative part is not there under rule 27(3). I agree with that. So, my lord, by invoking rule 11(5) of CCS.
How can you?
965, my lord.
Show me a law on that.
That is not applicable in the case of constable lawsuit.
Show me a law on that.
Because
Yes,
here
Mr.
what happened,
Majumdar.
my lord,
Can it be done? See, he has shown his colors. He's not come this side.
Yes, my
He
lord.
has come this side.
Not applicable.
Yes.
Because I'm just trying to assist.
Rahul Kumar.
There are a few judgments of the Delhi High Court which says that the CCS CCA rules should be applicable because of 102 of the CRPF rules. But the punishments which are given, if unless a notice is given, that lordship may like to see. When they want to invoke 102, then
They'll have to
102
give him a notice.
that we will invoke 102, we may give you something under 102 also. That perhaps is not the, I do not do that.
No, it's not.
Otherwise, punishments which are given in 102 says what is not specified in the CRPF Act and rules,
That will
you
be
refer to CCS. But then here the punishments are given.
specific.
So 102 will not come in.
Hmm.
What is not given in
In the rules, then that will
then they go to therefore that introduction of the presenting officer had come in, and in 2 or 3 cases where the presenting officer was being discussed by the Honorable Delhi High Court, Honorable Delhi High Court held 102 allows presenting officer, therefore even if absent in the CRPF rules, that will come in. Later on, the Supreme Court upheld the orders of the Honorable of our High Court, saying that no, it's a part of natural justice itself. But otherwise, Delhi High Court has held that 102.
But there is another decision. In that order, I think Mr. My Lord Justice Ete, that which I followed, therein it that this issue was raised.
Yes.
I think there is a Supreme Court decision therein that in CRPF, that is not mandated.
Mandated, yes.
It's not mandatory. I think in your case, only,
Yes.
that
The
I think there is
Chandan Rai case.
the judgment which I followed.
Lordship had decided
Followed.
2 or 3 cases.
That's what.
Connected together. Yes, madam.
No appeal on that.
No, they actually the department came to know about the disposal of those cases sometime few days ago. But Chandan Rai has been appealed from and status quo. The original order, Justice Ete's order has been stayed.
I think that order of mine also requires to be interfered with.
The division
Wrong.
The division bench judgment which is there.
I have a decision now with me. That was not there. Let them see. Let me see if somebody files a review. We will correct ourselves.
This part will be deleted from the video, my lord.
Yes.
Yes,
Show me a law on that.
Can it be on Monday, madam? Let me try.
It is clear case lordship, rule 27.
We will not interfere with the, were you given subsistence allowance for that period?
Nothing, lordship.
Sure.
No.
Why? Pay, forget it. But he is entitled to subsistence
I'm not aware of that. I have to take instruction. Whether it was paid on.
because this court interfered with the order. So that interference will go back to that date.
10,000.
Whatever the order of
Yes,
penalty is.
Yes,
Now, if that is from that period
Yes.
till his reinstatement,
yes.
FRSR, he will be under suspension.
Yeah.
If he is under suspension, forget the pay. We are not interested. We will not pay. We will give decisions that he is not entitled to pay. But he will be entitled to a subsistence allowance.
Yeah, well, I have to take instruction. And the use paid on.
Have you retired?
No, not yet. Working loss.
Hmm?
Working.
Working. Saturday. Saturday.
Saturday, Monday.
Why? We'll come. You also come.
My lord, Saturday.
Why?
My lord, I have some personal problems.
Because of Saturday.
My lord, my pre-program lordship.
Huh?
Pre-program, there is marriage ceremony.
Huh?
There is marriage ceremony in the channel.
Oh, marriage. Okay, Mr. Adhikari, when?
Monday, madam.
Monday too tied up. 29th. On the prayer of the parties, list this matter again on 29/4/2020. I think there is one judgment. Let me see.
Item 17.
All right.
So what is the Mr. Doctor, have you got it?
My lord, I had an interaction with them. My lord, they wanted to say the cashier on that relevant time, he was on leave. He joined on 10/1/2009. On that date, he found the case okay. Now on 12/1/2009.
No. The evidence that you gave me that day
Well-
shows that on the closure, the cashier was there.
Yes. No, it's correct, Mil.
Hmm.
He
And
joined
then
on-
that was Friday, Saturday, Sunday, something, then Monday.
Yes, on Monday when he opened,
Huh.
he found that
No, he closed and he opened.
he closed.
Huh.
And when.
Then where is the
closing-
question of he being on leave?
No, my lord, what happened earlier to that, from 10/1, before that, he was on.
Forget it.
No.
On 10/1 when it was closed,
No, when.
he was
closed-
there.
My lord, when he closed it, the other officer, advance officer, he was with them.
That's not the statement, mister. Where is that bunch of papers you gave me the other day?
That's my lord, I am giving you.
So there is a deliberate attempt to protect him somewhere.
My lord, your lordship can see the record.
We are only on the contempt,
Well,
quantum of the penalty.
if your lordship see the second chart, this is the more.
No. I want this.
This is the record.
So
The instruction which I am having, I am just giving to your lordship.
the prior that the key of the strong room and collapsible gate was in the hand of the cashier on the day of the incident prior to 10/1/2009. That is single custody with cashier regarding so and so was detected on 12/1. Then I found a
Your lordship, look
categorical
at
statement.
ME 16. At page. The record of the disciplinary proceeding, ME 16.
What is the name of the cashier?
Madhuram Boro. Lordship may look his statement at.
What is P/L?
Beg your pardon?
P/L in the attendance register, P/L. He was there on 10th.
On 10 years, he joined on that day. And
10th,
if you-
so he logged it. 11th, 12th, 9:45 he came
Yes,
and he was there from 9:10.
if your lordship look at ME 16, that will make the thing very clear.
ME?
ME 16, my lord. This is the evidence of the petitioner. The cashier came on 9:30, left the office at 3 on 10/1.
Mr. Dotto,
Yes,
I accept that he was absent before 9. If this loss had occasioned on 9, he would have detected it on 9th itself,
the loss occurred on 12/1.
12th. So 9th, the cashier locks. So how can he?
Ninth cashier did not. The
Yes,
cashier was not there, man.
yes, ninth cashier is there.
He joined on.
Sorry,
10th.
10th.
10.
10th, the cashier is there, he takes money, he locks.
He
So
locks
if
it.
there is a loss of money,
He logged in the presence of the advance.
whoever it
Mr.
is,
Kalita.
that up-to-date thing would be done. Normal banking parlance, you will work out, lock it. So on 12th, this loss occasioned.
Now, yes, you'll also.
10th, both of them are there. How can you proceed against one, leave the other? That reason, you might have a good reason, but I want that reason. And the statement is that the key was with him.
Then I'll make the thing clear from ME 16.
ME 16, where is ME 16? Yes, ME 16.
ME 16, this is by Ravindranath Chakma, the
Ah,
petition.
strong room or dorza, collapsible gate, aru cashier or hatot ase.
A lordship may look it from there, branch or sabi, manager or hatot thake.
Branch or sabi manager, you come to
Yes.
16. Strong room or dorza, collapsible gate or sabi cashier or hatot
Now,
ase.
before that, my lord,
Hmm.
front or sabi, branch or sabi and front or sabi, these are
Hmm.
very important. First thing, you'll have to cross that first.
Hmm.
Front or sabi, manager or hatot, or manager or.
Suti thakile, incharge or hatot
in charge
thake.
of hatot thake.
Fine.
Then strong room or dorja or collapsible gate or sabi, cashier or hatot ase,
Hatot ase.
arambani did not pour.
Arambani
Now,
did not.
strong room will come, my lord, after opening of the
Mr.
branch and.
Mr. Doctor, in a bank, you may have access to the front room. You may even have access to the branch manager's room. But the strong room is a different concept altogether.
Your lordship is very right. But then unless supposing this is the branch. this is
I
the
come
front
in,
room.
but I come into this room, but say this is the strong room. How will you enter?
From this room, you'll have to come. Then
You
the-
come in, you
Yes.
come in. But for entering this, there is another barrier. You will have to unlock it.
That's
The
thing.
key is with the cashier.
No, the front room, my lord, branch or sabi, then front or sabi.
Front
manager
is,
or hatot thake.
front is something which is prior to the strong room.
Therefore, my lord, you'll have to open the branch first.
Fine.
Then after opening the branch, you
You
can
come
enter
in.
into the strong room.
Huh. Now tell me, if the key is with the cashier, how the manager alone enters and takes out the money?
There, that's the reason, my lord, your
Oh.
lordship can be.
And you come to the next one,
Strong. room or-
17. Walter Sabi BM or cashier or hatot thake.
Yes. Then.
So the money is in the vault.
Yes, money.
So
money is
both
old.
of them will have to open.
No, but Bolt's money was not taken up. It
Okay,
was in the
strong
trunk.
room.
Some money, 2,41,000 cash, that was in the trunk. So
Trunk.
it's supposed to have been in the vault, but there was an excess money. So they accommodated in a trunk.
So tell me, strong room or dorza, collapsible gates or sabi hatot thake. Now, after this, how did you exonerate the cashier?
Then,
You just show me that we will uphold this penalty imposed on the petition.
then last line you lost,
Hmm.
can you see?
Hmm.
Just open. My lord, somewhat case Dr. Homer,
You read 19.
Bakosor, Vitorot, Anumani, 241 lakh, Asi.
Hmm.
Now he is talking about, that is on 10-1.
Hmm.
Then, my lord, the lordship kindly come to the next thing. Also, Vitorot offer remittance box, Vitorot Rakibo, Loga Hoise. Then you lordship may skip that. Then 12-1-2009.
You are reading?
My lord, page 12.
No, please come to 19 in page 11.
Yes.
সংগ্ৰামৰ ভিতৰত আছিল 10-1-2000 ইংৰাজী তাৰিখলৈ what is that last তাৰিখলৈ what is that word
Ratipur.
no strong room ভিতৰত আছিল 10 তাৰিখলৈ
তাৰিখলৈ দৰ্জা বন্ধ ৰখাৰ সময়লৈকে
সময়লৈ দৰ্জা
ৰাতিপুৱা কেছ বাহিৰ কৰাৰ সময়ত হাফবেলি ক্যাশ হাফবেলি প্রসেসলি হাফবেলি মেথড হাফবেলি ক্যাশ রাখার সময় বাকচৰ ভিতৰত আনুমানিক 2.41 লাখ হ'ব।
নালাগে।
Now,
দুজন
he's
আছে।
talking about 10/1/2009.
এই ল'ৰাটো মাতি
That
দিয়ক।
means he is acknowledging that the beginning
Well,
this
but
much
why?
amount was there on 10/1. And the manager left the premises last,
Page?
page 11, as the lordship say, in ME 16, last 2-3 lines, my lord.
আপনি যখন
And if you lordship look at, the manager here himself stated that the manager, cashier left at 3 PM. Whereas he left after that, somewhere he stated. He left at 4 o'clock,
আপনি বই দিন।
and the top your lordship will find.
Okay, but this does not give it. This is his statements.
Yes.
But I wanted your,
Yes.
that when the incident occasion
Yes,
and
sir.
cash was lost from the
Yes, yes.
from
your
the
lordship-
strong room,
Your lordship may kindly see. that
what is your instruction? Why was he left out?
He was left out because my lord, one instruction I have got, I just,
This one?
yes, yes.
Okay. So on the date when this cash was kept in the vault, that is on 10,
Well,
the manager, the cashier was there,
Keshav was there.
locked it in the
Yes.
strong room.
My lord.
Huh? He again opens it on 12th.
12.
Money is lost. So why the manager only? Why not the cashier?
My lord, the cashier, there is no such evidence.
No. This is more than enough, Mr. Doctor. At least we have seen remote possibility, you by preponderance of probability, you draw up proceedings.
Now, Ashwini, my
But
lord.
here he is locking it, saying that the money is inside.
Now,
You are
what the-
admitting that.
Now, what the petition.
Just show me one evidence somewhere that without the cashier being there also, he could have opened. That much only.
My lord, if your lordship has seen that. I can
Because
once
here
again-
also you see, the cash, the strong room key is most probably with the cashier.
One is with the cashier, one is with the, and the lordship may see. He has somewhere, I'll take your lordship to that. Your lordship may kindly see ME 14 at page 9,
ME 14,
page 9.
cashier
last-
statement, yes.
Last 3 lines. my lord.
Hmm.
Here, Badeo manager sare 12/1/2009 তারিখে strong room or sabi এপাত মোৰ লগত ৰাখিব লাগে বুলি খুজি লয়। So he has taken on 12/1.
You are reading serial number
Serial page 9, my lord.
7,
Last
8,
three- last 4 lines.
9.
হ্যাঁ, 12 তারিখে বুঝলে।
Yes, you are reading, Mr. Dotto.
My lord, can I read from
Place
page-
7
page
onwards.
7 onwards?
Hmm.
Number 4, serial number 4 में
Hmm.
let me see. 10/1/2009 তারিখে মই মোৰ কাৰ্যালয়ত উপস্থিত আছিলোঁ। এই তাৰিখত মই মাননীয় কন্দৰ্প কুমাৰ কলিতা অফিচাৰ এডভান্সৰ পৰা কেছ হিচাপ
বুজি লওঁ।
বুজি লওঁ।
Cash
কেছ বুজি
বুজি
লওঁতে
লোৱাটো
চেফৰ
safe
ভিতৰত
হয়।
3084 আৰু
3084
চেফৰ বাহিৰত
34
10/1/2009 ইংৰাজী তাৰিখে লেনদেন শেষ কৰি হিচাপ মিলাৰ পাছত চেফৰ ভিতৰত 45,50,000 আৰু
Say for Victor,
Say for Victor.
2,41,733 টকা steel trunk পত্ৰ আছিল থোৱা আছিল strong room বন্ধ কৰাৰ সময়ত মোৰ লগত ঋণ
Now,
বিষয়া-
Mr. Dotto,
Yes,
as per serial number 5,
yes,
so he is admitting that he had kept 241,533 in
Yes.
that steel trunk.
yeah, he's admitted.
Okay. Then 6, strong room বন্ধ ৰখা সময়ত মোৰ লগত
ঋণ বিষয়া
ঋণ
ঋণ
বিষয়ৰ
বিষয়া
শ্ৰীযুত কন্দৰ্প কুমাৰ কলিতা আছিল.
Yes,
So the branch manager is not there,
yes,
right?
the manager advance was there.
Strong room বন্ধ কৰাৰ আগতে মই চেফ ষ্টীল ট্ৰাংক তলা আৰু ষ্ট্ৰং ৰুমৰ গ্ৰিল আৰু দৰ্জাৰ তলা
ভাত
ভালদৰে বন্ধ কৰিছিল.
কৰিছিল।
So the closure is by the cashier.
Yes,
Now,
but he
টকা
was
থকা
there.
ষ্টীলটো 12/1 তাৰিখে দৰ্জা আৰু গ্ৰিল তলা খোলাৰ পিছত দেখা নোপোৱা মাননীয় শ্ৰদ্ধা প্ৰবন্ধক শ্ৰী ৰবীন্দ্ৰনাথ শৰ্মা আৰু শ্ৰীযুত কন্দৰ্প কুমাৰ কলিতা মহোদয়ৰ মাতি আনি অৱগত কৰিলো. Now, tell me, how was it? Who entered? The keys are with him. Who entered? Who has that key? Has he made a duplicate key?
No, there are two keys, madam. One is with the cashier.
No, both the keys have to be used together.
Now, the other manager advance was there.
So have you proceeded against him?
No,
Kolita.
manager advance is not at all.
You have not proceeded against Mr. Kolita. You have not proceeded against Mr. The other charges, he is fine. We will see to that.
Mhm.
But why not this too? This is
We
public
can-
money.
We can proceed, my lord, when there is some allegation against.
Show me.
There is no.
With this statement also, there is nothing. Mr. Doctor, I put the money inside. I lock it. Along with, say, this man. And we go home. 12th I come, open. I open. I don't find the money. I lock. Now there has to be an evidence somewhere. Just show me that without my presence also Mr. Roy could have walked in and taken away that money.
No, it.
Then corroborate it with the 9:10. He came to office on that day on 9:10. I reached at 9:45. So within this half an hour, he might have taken the whole steel trunk with him. Show me that evidence somewhere.
And from the evidence of the petitioner, your lordship has seen.
Hmm.
That he came on that day on 9:10 and he left at last 4 p.m. Whereas the cashier, he came on
45.
9:30 and
Hmm.
left at 3.
Cashier.
Cashier.
Wait.
Well, his work was over
On 10th.
on 10.
That means then you
Exactly.
come back to the statement of the cashier. He left after locking.
After locking.
Now show me that he has, that only one key is required to open that strong, not 2 keys.
So far, I mean, so far bolt is concerned, my lord. In opening the bolt, that requires 2 keys.
Strong room, only 1 key.
Strong room is 1 key because, my lord, when you're going to open the bolt, that 1 key is with the manager.
Vault, we
1 key is
understand,
the
but the
cashier.
strong room,
Strong key,
is it a lock requiring 2 keys to be operated together to open it,
possibly,
or a single key will do?
my lord,
No evidence to that effect.
to that extent, of course, so far, my rough idea goes, for opening the strong room, 1 key is sufficient.
Can Mr. Dr. just have a instruction on that? Can you take me further on this?
Well,
8 onwards, can we just go through? We find something.
well,
The presenting officer has said, my lord, on the day the lordship has seen, both the keys were with the other man. There's a specific.
No, we'll come to it. ঘটনাটো মেনেজাৰ মহোদয় আৰু যেন বিষয়ে
Lordship is
চন্দ্ৰপ্ৰতিমা
reading.
কলিতা ছাৰে জনাৰ পাছত সেইদিনা মনে মনে থাকিব পিছত দিব এটা আলোচনা কৰিব লাগিব বুলি মহোদয়ে লেনদেন আৰম্ভ কৰা হৈছিল আৰু আগতে ষ্টীল ফাণ্ড কিমান টকা আছিল মই হিচাপটো ডিনমিনেশ্যন সহি মিলাই লোৱা হৈছিল এই নতুন কথা আৰু জনাব মানে পুলিচ মাননীয় Come to serial number 12.
Yes, well,
Hey, can you read? সেইদিনা মই কোনো এজন staff হয়
from top menu.
no 12 itself.
Oh.
Plus para 12. That page 9, para 12.
Yes.
সেইদিনা মই
কোনো এজন staff এই কাৰ্যত জড়িত হ'ব পাৰে বুলি ঘনাক্ষৰেও ভাবিব পৰা নাছিল কিন্তু এতিয়া মই নিশ্চিত ঘটনাটো মাননীয় শাখা পৰিচালক শ্ৰী ৰবীন্দ্ৰনাথ শৰ্মা ছাৰ জড়িত আছে কাৰণ মাননীয় ছাৰৰ কথা ফেৰ হৈছে মাননীয় অধ্যক্ষ চেয়াৰমেন ছাৰেও আগতে নিচা মাতিছে মাননীয় অধ্যক্ষ মহোদয় 11/1/2009 তাৰিখে ফোন কৰিছিল তাৰ পাছত যেতিয়া মাননীয় মেনেজাৰ ছাৰৰ ঘটনা সম্পৰ্কে কিয় জনোৱা হোৱা নাই তেতিয়া মেনেজাৰ মহাশয় এছিয়াৰ জনাবলৈ বাধা দিয়া বুলি নিচা মাতিছিল ইয়াৰ বাদেও মেনেজাৰ ছাৰে 12/1/2009 তাৰিখে ষ্ট্ৰং ৰুমৰ চাবি এপাত লগত থাকিব লাগে বুলি খুজি লৈ যায়
read it again. ইয়াৰ
this portion
বাদে ইয়াৰ বাদে বাদেও মনোৰঞ্জন ছাৰে 12/1/2009 তাৰিখে ষ্ট্ৰং ৰুমৰ চাবি এপাত মোৰ লগত থাকিব লাগে বুলি
খুজি লয়
আৰু 15/1/2009 তাৰিখে
he registered
সহি ঘূৰাই দিছিল মোৰ মাননীয় মনোৰঞ্জন ছাৰৰ ওপৰত বিশ্বাস আছিল কাৰণে সময়ত মই
ইমান গভীৰলৈ ভাবি চোৱা নাছিল
আৰু সেই বিষয়ে so this key was handed over on 12/1
yes
right
yes
so till 12/1 the key was with the cashier
yes
so 12/1 the whole incident happened by the time the manager had the key the loss was already done
12/1 my lord this has got not much meaning
no this has a meaning because that key said that the key was taken from me on 12/1 by the manager if the key was taken on 12/1 how can he have the key on the morning of 12/1
no but my lord there is no evidence I did not find till now that there is any evidence against the cashier that he has done all these things there has to be certain pinpointed evidence against the cashier even there is no such allegation
anything more Mr. yes
My lord, your lordship is actually key
for my lord I am correct my lord. For opening the strong room 1 key is there
one key
1 key and for opening the vault 2 keys
strong room is one key
strong room is 1
yes
with him, it is with him. The evidence is it was with him. So he has given on the 12th, said, manager said, one should be with me, give me. And then again, it was returned on 15th.
15
So, my lord, it is happened.
anything more Mr. Rutto?
now my lord the evidence offer manager is very approximately connected
The subsequent charge 2 onwards
And then
we are with you
2 and 3 your lordship kindly see.
Huh?
2
we
and
are with you we are
what-
with you
what he did
but the main issue what is troubling me is why was the cashier not proceeded he's still in service
now
he's
yes,
still in
yes.
service
Now my lord assuming that he is guilty but does it mean that because he is guilty
Therefore.
No, no, no.
The
The
manager.
subsequent action of the manager demonstrates an act which you can draw a presumption of lack of confidence on. And lack of confidence is enough to even dismiss it.
So for that, it is, the law is very well defined.
Well clear. But the question here is, when there was more than person involved in the whole accident, why on him? At least for that recovery part of 2,41,000, which was made solely from him.
Now, your lordship, can you see, when there is such type of allegations, the first duty cast on the manager, he should
Just
have
to inform,
reported to
or a police.
authority as well
That
as
is a
the
mistake.
police.
That is a mistake. But will that exonerate, say, a person who is directly involved in the act? Kondropa Kolita, the cashier, both are handling the cash on 10th. 10th, the key is with the cashier. 12th, the key is with the cashier. He opens, but nothing done. Does it not send something? His action is totally, we are not even on him. But when the question of quantum comes up, we can examine as to why this partial action was taken by him. You saved him.
No, to that extent, my lord, I don't want to go myself, because in the absence of very specific evidence. Now, your lordship, kindly see the next part of what this gentleman has done. My lord.
That action cannot be supported. For
one
that,
of
the penalty is appropriate.
No, what he.
First day I told you,
Yes.
to that extent that penalty is up, but the recovery part, how can you solely base it on? When punishment, what he has done, cannot. But for that loss, how is he responsible?
In the face of, there is. two other
These
parties.
statements. That part only I am on. Penalty, loss of confidence on him because of this, that step of creating a false loan thing, entering by himself, be that as it may, whatever the basis.
Your lordship is well aware about a case of State Bank of India manager. What he did, my lord, while he was doing the service in one of the branch, he allowed loan in favor of his wife. Now, he knew that if he do that, there will be charge sheet against them. He realized he committed a mistake. Then and there, he cancelled it. But then the management has charge sheeted him, saying that it's a misconduct and we have lost confidence on you. Then the High Court has passed a removal order against his service. He went to Appeals Court. Appeals Court said nothing doing. Confidence has been lost. So,
Because bank employee, the free guiding principle is loss of
loss
confidence.
of confidence. Although the bank.
This penalty is perfect, but what I am on is the recovery.
Quantum.
Recovery, no, the recovery part. Because you have recovered that 2 lakh from him. He has made good, you have paid that
Yes.
2 lakh.
Immediately.
Return that to him. We will maintain this.
Lord, I leave up to you, lordship.
Okay.
Otherwise, my lord, the charges, as your lordship seen, is a very, very difficult to stomach.
Mr. Dotto, that penalty that you have imposed, even if you had imposed a dismissal from service, we would have upheld it.
Even I thought, my lord, it's a case of dismissal.
It was a case of dismissal, open and shut case of dismissal. But you showed leniency, compulsory retirement, and take it from me, this court is not going to touch that. But we are on the recovery part. Because he had made a specific claim that this money was only recovered from him. So we will interfere with that, give you liberty to carry out required exercise, find out the persons who would be responsible and then make recovery. To that extent we can do.
I mean, it may be said that if requires, we can follow up doing action is that.
No, we'll not say anything like that. This is for my conscience clearance. I was asking you.
And I think that avenue is still open.
Huh?
But I saying to you, Lordship.
Now that you cannot. Now you cannot. Okay. Itu শনিবারে লগাই দিম। We'll pass orders on Saturday.
Saturday, my lord.
Saturday. You need not be here. We need not be here. Nobody need
I
be
think
here.
our argument is over.
Your part is over. Only my delivery because I have a shortage today.
I'll be there on that day.
No. You are not there also, no problem.
Yes.
Heard the parties at leg list again on Saturday. Give me 2024 for delivery of orders.
Lordship will excuse my absence on Saturday.
No. You need not be here.
My lord, the discipline record is with the Lordships.
If Mr. Dotto is here, Saturday I'll give it to you.
Obliged.
But Mr. Roy, we are not going to interfere with the penalty.
Yes, I leave it to you, Lordship. Lordship
Only
has
that-
rightly said, bank
that
employee. I understand. But only, my lord, he has been made scapegoat only, otherwise, other.
No. Your actions are not
No, that's,
befitting
that, my lord.
a branch manager. I'm
He-
sorry.
His primary responsibility was to immediately.
They
inform-
gave you a lenient penalty.
That's that, I understand.
They should have dismissed
But
it.
then I leave it to Lordship of the quantum, my lord. So
Not the quantum, the recover.
That's. Obliged. Leave it.
18.
Wait, please, your lordship. Lordship, we have tried to contact with our client, but till date we are unable to do so. And
If
the
you are
last
unable to
date-
do so,
and the last date, the respondent authority.
we have
has-
already given you time.
Yes,
No
lordship.
further time.
Okay.
You want to
But,
argue, you argue.
One prayer I would like to make that the respondent authorities have said that the petitioner was given the promotion, but he has refused to do so. So kindly that record may be
Yes,
produced.
Lordship.
When?
That is verbal instructions only.
When? Have you clarified that? There only two things you have to do here.
Tuesday, Lordship.
No, today. Just phone. Phone the joint director. His contention is that he is in Sonitpur, district cadre, 2006 appointed. The person appointed in 2008 in Sonitpur under the joint director, 2013 they were promoted. His case was not considered. Why?
Now, as per verbal instruction, he was promoted, but he has not joined.
So just confirm that we will dismiss this. 2 o'clock.
Yeah, tomorrow, Lordship.
No. Today. 2000.
Because Lordship.
2014 matters.
No, verbal instructions is by.
See,
DP work, Lordship.
2014, 10 years you have not cared to file a written statement. Have you? Written argument.
At 2 o'clock.
At 2.
Lordship.
But I wonder instructions at 2 or we are interfering, we are directing for our promotions.
He has not joined, Lordship.
That we don't know.
continue-
Tell me with confidence. I'll record your thing.
Lordship. Obliged.
2 o'clock.
Item 19.
Where is the FIR that you did not understand to do, that you were guilty? Acceptance of guilt was under that, a mistaken notion of the matter. Where is your appeal? Copy of your appeal.
Appeal. Copy of the appeal is not on record, but.
Why?
disposal
Have you
of it-
taken this plea there?
The disposal of the appeal is there.
Forget the disposal. Have you taken this plea?
Prior to that, Lordship will see some procedural lapse on their part.
I'm not on that. But have you taken the plea?
The guilt, my lord, what would be admission of guilt or what would be a plea of guilt? Lordship will have a look at the charge. You were absent on so and so date. Fact remains I was absent. Can there be any other way than to say that yes, I was absent on that day?
Come to that.
There can be no other way. Let us have the charge sheet for a moment, my lord. What is the charge? Page 29. The charge. In that he on so and so absented himself without leave from 600 hours to 1900 hours, a period of 13 hours on 14/5. In that he on so and so absented himself without leave from 810 to 1300 hours.
No, Absented himself without leave.
Without leave, yes, yes.
That's it.
Without leave. So I was absent without leave is a statement which I cannot deny. I was not there in the office. I did not
Okay.
have a leave certificate.
Okay.
That is there.
Come to page 30. Come
Now-
to page 30.
30.
Hmm.
Yes. Yes, accused number so and so of so and so is found guilty of the charges. Record of evidence is read and transferred.
No, page 30. That where you showed me 29. The
Yes.
next page. Proceedings.
Proceedings on a plea of guilty.
Huh.
That is, I'm reading. Accused number so and so is found guilty of the charges. Record of evidence is read, translated, explained, marked, exhibit case signed by the court.
Hmm.
Do you wish to make any statement in reference to the charge or mitigation of punishment?
Hmm.
Accused declined to make any statement. Do you
Hmm.
wish to call any witnesses to factor? No.
No.
Now, Lordship will find that I was told about the charge sheet on 28/8 itself. On
Hmm.
25th of August, the charge sheet is
Hmm.
issued.
Hmm.
Lordship will just have if Lordship allows me, just what happened and how it happened. I am placed under close arrest on 14/7/2012, madam. I am placed under close
Show me
arrest.
your appeal memo.
Madam,
Show me your appeal memo.
appeal memo, my lord, I have made a statement in the.
Why?
It is
Why?
there on the record with them. It can be.
No,
easily for-
forget the record.
I don't
Why
have-
was it not annexed here?
I don't have a copy of it.
Show
I
me your
actually don't-
statement to that effect.
My lord.
Show me your statement to that effect. You know, look, I don't need anybody. Next time I look into my ear. Lage my dictation and it was, it won't go it out.
Rejecting the appeal. No, that statement is not there. That statement is not there. The appeal memo will be there with the records, not it can be easily put. That statement that I have lost it is not there. Lordship will only see one.
You have not even mentioned that you don't have a copy.
No, that is.
So we, how will we know? What is your pleas taken there?
In the
appeal memo.
The order will.
When Mr. Majumdar drafts this writ petition, it would be a different ballgame altogether. But we want to know what was the grievance of Mr. Qazi Sofiul Islam.
Lordship will at page 42. My grievances in the appeal are recorded. are protected.
42. Okay, come.
Being agreed by the findings of the SSFC, the petition submitted the instant security petition addressed to DG with a prayer to withdraw the dismissal order to allow him to join the service. In the petition, he has written that his mother was suffering from illness for the last several years. In the month of May, June 12, his mother became serious and her critical condition was informed to him. After getting such information, he got confused as he was the only son to look after the mother, and so he hurried to his mother on 13/5 without taking leave and joined his duty on 15/5/12. On the same day, he again hurried to his mother and joined duty on 23/5/12. Again, due to some condition, he hurried to his mother and joined on duty on 28/6/12. During the trial, he stated the facts about the serious condition of his mother before the authorities, and he also apologized for the absence without leave. There was no other source of income, and entire family was depending upon his income. Due to dismissal from service, he, along with family members, was passing the days with great hardship. The perusal of record reveals that on being arraigned by the court, the petitioner pleaded guilty on the charges, and hence, as per procedure, no witnesses were examined, and their statements contained in the ROE were read over, explained to him, and attached to the proceeding. But here, Lordship will only can see. Hence, as per procedure, no witnesses were examined. And their statements contained in the ROE were read over to him. Now, in the ROE, my lord, when the statement of the witnesses were recorded, they have given the records to show that
You had admitted. Forget it. Now
There
you
I have
pro-
not admitted.
I'm on a
In
different
the
point
ROE.
altogether. You
the
proceed.
petitioner was found absent in the morning, so and so he reported back on 15/12. He again absented himself without leave and reported back to 29/12/2012. On the same day, that is 29/12, he a petitioner once again absented without leave from STC based Jodhpur. The two registered letters dated so and so were sent by the SC to petitioner, and it is home address to join his duty forthwith. Petitioner voluntarily joined duty on 28/6/12 after absenting himself without leave for 30 days. As regards illness of his mother, STC BSF Jodhpur has written that the petitioner neither applied for any kind of leave nor ever informed anyone regarding illness of his mother till the date of his dismissal from service. on 28/8/12. During the hearing of the charges under BSF Rule 45 by DIG BSF STC Jodhpur, he neither informed about the illness of his mother nor produced any medical document. During trial as well, he did not inform any such fact to the court. So the contention of petitioner regarding the illness of his mother is baseless, false, and
Now, Mr. Majumdar,
my lord.
why I was asking for that appeal memo is because of this statement. Come to page 5.
Page
5.
5. Yes, my lord.
Read the line. In such state of mind, the
In
petitioner
such
left
state of
for
the
his
petitioner left for his home on 13/5/12, but he could make arrangement to come home, and having realized that he should officially obtain the permission for leave of absence, he returned it to SCC BSF on 14/5/12 itself. Thereafter, he consulted his immediate superiors who advised him to leave for his home if it was an urgent matter and that the leave could be regularized at a later date.
So
But-
where is this plea in your appeal?
That I had informed someone and left. My lord, that appeal was not given to me at that point of time, therefore I have not annexed it. It is not there even on today's record, my lord, it is not there with me.
So, no,
Just
you
one
said
record.
it will be, your pleas are relevant from the statements that are there in the order, disposing of.
No,
That aspect is not there.
that
So
exception,
that
whether it was-
absence is unauthorized.
Yes, there is no denial of
Then-
there is no denial of the fact that I was absent. on
And you
this
were in the
particular-
training phase.
I was in the training phase. Now,
And you leave as per your own convenience, come back as per your own convenience,
and after I come
without
back,
a justifying as to why you wanted to.
after I come back, more than a month after I come back, I am put under close
Fine,
arrest.
fine. That's their discretion.
Possible can be appreciate the situation. I am put under close arrest. I am given a record of evidence.
Hmm.
Thereafter, I am asked that in my trial, do I require a defense assistant? The defense assistant is appointed on 27th of
And they
August.
give you an opportunity, you can even engage an advocate.
And they do so on 25th, directing me to do anything that I want on 26th while I am under close arrest. I am not out of the, I am not out to go and engage an advocate or do anything. I
Where
am
are
under
those
close
pleas
arrest.
taken?
Madam,
Where are those pleas taken in your appeal?
in the,
That you were not in a position to defend your charge.
their appeal order says that I was under close arrest. Their appeal order
Forget
says
it.
that I was.
No, show me. Where was that prejudice? Where have you taken that plea? That because of this, I could not defend.
My lord,
Because of this, I was under a misconception that I
My lord,
admitted to my guilt.
requiring a class 10 constable to bring on these points of law in his.
He's a constable. He's in a discipline force. If this is the nature,
That
at the time of his,
if
at the time of
these
his
people-
entry,
These people start to understand how a dismissal of appeal will lead to a lead petition and what are the grounds. I
and
have to
today,
take.
these people are put back by this court.
I'm not asking
It
for.
will,
a
it will
putback.
be,
No,
setting a very
that's
wrong
simply
signal.
appreciate. It is never a putback. It is always that the proceeding that was conducted was wrong and that he should have a fair chance. That is all that is always there in a writ.
Anything more?
Lordship will kindly have only this part. He was under close arrest. He was allowed to have a defense assistant, what is they want to say.
Hmm.
On 27th of August, a defense assistant is appointed. On 28th, the trial starts when my plea of guilt is recorded without giving me time for reflection, without giving me even a consultation with the defense assistant. And I am terminated on the same day. Did I have a chance of even having a defense counseling? Did I have a chance of even understanding what is coming down to me?
Where is your that plea?
Lordship will have in the appeal, my lord,
No. In your writ petition.
in my
Where is it?
petition, my lord.
Show me that plea.
Yes, my lord. Lordship will have para 9. Lordship will have para 15, para 16.
কমাই দিয়ক, বাড়াই দিয়ক। এইটো 17 আছে, 20, 25 মান কৰি দিয়ক।
Para 17, my lord. Page 12, just above para 18, my lord. Sir, I could not, page 12, just above para 18, the last line of para 17 has said that I did not even have an opportunity of counseling with my defense counsel. I could do nothing. 27th evening, I am told that this is your man. 28th, my plea of guilty. 28th, I am terminated.
Was there any statement there that the plea of guilt
Yes.
that was recorded, was
Yes.
so recorded under coercion, pressure, something like that?
Yes, coercion or pressure may not be the exact words, my lord, but that he did not understand what, before even he could understand what had happened, it was done. Is there, my lord?
Yes, Mr. Parasar, what do you have to say?
My lord, because of the 3 times of absent, my lord, 3 FIR, my lord, I have the original record with me, my lord. 3 times FIR was lodged, my lord. On the first FIR on 14/5/12, second again on 15/5, and third FIR on 30th of May. And subsequently, when my lord, and twice my lord, letter was sent to his home, my lord, asking him to rejoin in the service, my lord. When he come, the proceedings is initiated, and every opportunity was given, my lord, and he pleaded guilty, and my lord, regarding his paragraph, my lord, paragraph 17, he has said, my lord, I have given reply in para 20 that my lord, friends of the accused, my lord, of his choice, and this opportunity was given to him. He declined to that, my lord.
No, his case is different. He said opportunity given,
Yes.
but I could not avail it because I was under close arrest. What do you say on that?
Close arrest, my lord, yes, but regarding, my lord, that was done, my lord, on 28th, but at that point of time, regarding the trial, my lord. At the time of trial,
Here I have to sit down and consult. That is what they want me to do.
my lord, as for the record, my lord, record is.
You should have given him opportunity.
Opportunity has given.
You should have allowed him to go to the house of the close friend, have a cup of tea there. Then sit and talk, discuss. Follow that from today onwards.
My lord.
In his name, it will be that principle will be called this petitioner's name today onwards. Whenever you drop such proceedings, send that petitioner to the house of the close friend. Let him stay there for 2-3 days. Let them have a talk, develop that confidence, and thereafter only examine.
One thing in this, my lord, during that he is staying in the RCD, my lord, before he leave, my lord, since 28/3/12 to the dismissal on 28th of August 12.
Mr. Parasar, you argue on one point.
No, not a single.
He left without any information. That is enough. And that was in the RTC, not in service. Mother's illness was never brought on record.
After thought, my lord. That is after thought.
Mr. Muzumdar, Saturday. List this matter again on Punivar for delivery of orders.
Obliged.
10 years down the lane.
My lord.
10 years down the lane. Not even completed training.
Not a problem.
He was a recruit here.
How old was he that time?
22 years.
22. Not much.
This honorable court has held that that age would not be material. In case of a reinstatement in service, my lord, this honorable division bench has held that the age would not be material.
We are not satisfied with your conduct.
My lord, he left within 2 months. Not even completed 2 months. First left he went, my lord, on 14/5. Not even completed 2 months training.
If there was some material like you have projected in your petition, we would have understood.
Nothing.
But that is not the projection of the petitioner.
The petitioner has in his appeal also stated that his mother was not feeling well there. And the other point that he was allowed
information
to the
authorities.
That is probably will always be denied. by the authorities. Who will take the responsibility? I allowed him to do.
No. If it was there in the appeal,
In the appeal, my lord, it said that I
because
had-
it's not there
even
in the deal, when they were dealing with that,
in the,
that issue was not there. And one thing, what I found is when these authorities, the armed forces,
yes, sir.
deal with such issues, they deal with each and every view raise.
Yes.
You also said that this here you will get my pleas are there.
Mhm.
It's not there. Anyway,
But
fine.
one thing is, my lord, that when he writes the appeal, he writes during trial, he stated the facts about the serious condition of his mother, which was never recorded. That was never recorded. In the appeal itself, he writes that I talked about my mother, the only thing written down was the guilty part. Not the
You
rest.
also know, I also know, we all know how the proceedings are done. But that has to be brought somewhere to substantiate.
That appeal
For us
copy is
to,
not with
for us to
That
commit.
appeal copy is not with me, my lord.
Otherwise, statements made in the writ petition.
I do not know what was written in the appeal. I could only trace
And
out
that
what was.
too by a person like Mr.
Hey.
I didn't use his name. Why are you showing towards you? I never said his name.
All roads lead to Rome, my lord.
Not this matter, Mr.
My lord.
Some other case.
Supplementary course list, top of the list, item 31.
Huh? Done. Yes.
May I please, your lordship?
Hmm.
Lordship, the petitioner was working in a great,
What happened to that third post? Filled up.
field of lordship?
Filled up subsequently.
But right now, as per the instruction of my petitioner, another post is become.
You can't have a automatic. That has to be put up for recruitment. You can only apply.
Yes,
And he
And that,
initially, on the last time, he applied, he participated in
he
it.
participated. So that is a closed chapter.
Close.
Your regularization not permissible. We can only provide one thing, that in the event they advertise that post, this is a high school, it will go before that commission now.
Commission.
So if that commission advertises that post, we can only make an observation that if there is an overage, you can make an application, they'll consider for condonation, and they will give you some weightage for the services you have already rendered. Mr. Kaushik will also not dispute that, right?
Right.
This much only?
Yes.
We are not interfering with the earlier thing. We'll only record your statement that there is a vacant post
Second post. Lordship.
and the petitioner be given an opportunity, then we will put this to work.
Yes, Lordship.
Dispose of.
High level. Lordship.
Daily course list, motion item 20.
May I please, Lordship? May I please?
Some horoscope has come.
Right,
Let's
right.
read it.
My lord.
Yeah.
Okay. Show me who is studying in the school
My lord, kindly turn to page, my lord, 26, my lord.
of the writ petition.
Yes, my lord.
Okay.
My daughter, my lord, Humaya Akhtar,
40,
26.
26.
26. Students unique number. And my daughter name, name of the student, my daughter Sumaya Akhtar. And my lord, kindly turn to page 22 also, my lord, register. Attendance, page 22.
Class
Page 22, my lord.
22.
My lord. My lord, rule number, my lord, 40, my lord. Attendance. And my lord, 23, my lord, page,
Shumaya Akhtar.
my lord, to page, kindly turn to page 23, my lord. Please,
Serial number 40.
serial 40.
Roll number 40.
Sumaya Akhtar, madam, present.
Hmm.
She is my daughter, madam. So,
Hmm.
that is why I was selected, madam.
Yes. What do you say? Yes.
Madam. As per the instruction,
As per
There
the
is no-
instruction, it says
there is no.
no student, but he has brought on record this, negate this. If this is wrong, we'll take whatever steps is.
Resolution also reflects that, madam. Can you turn to page 40? Resolution also reflects that I am the guardian, madam. Can you turn to page 13 and 14? Relevant portion, page 14, madam. Middle portion, madam, page 14, madam.
Let the DU confirm this one.
As per third agenda of the meeting, the process of the constitution of new school management committee. is
Come to the vernacular.
My lord. My lord, page 19, my lord, relevant portion, my lord. সভার তৃতীয় কার্যসূচী মতে বিদ্যালয়ের নতুন পরিচালনা সমিতি গঠন প্রক্রিয়া আরম্ভ করা হয়। সভাপতি পদের বাবে 4 জন পিতৃ মাতৃর নাম প্রস্তাব সমর্থন করে। পিতৃ মাতৃ means my lord guardian from the of the students, my lord. এই পরিপ্রেক্ষিতত সভাপতিয়ে সদনৰ পৰা 5 জন মুৰব্বীক সভাপতি আৰু উপসভাপতি বাছনি কৰিবলৈ জুৰিত পঠায়।
Read again. সভাৰ তৃতীয় কাৰ্যসূচী
my lord,
বিদ্যালয়ৰ নতুন পৰিচালনা সমিতি গঠন
কৰা হয়।
আৰম্ভ কৰা হয়।
সভাপতি পদৰ বাবে
সভাত
4 জন
উপস্থিত ছাত্ৰ ছাত্ৰী পিতৃ মাতৃ
চাৰি জন।
তৰফৰ পৰা
my lord.
সভাপতি পদৰ বাবে 4 জন পিতৃ মাতৃৰ নাম প্ৰস্তাৱ সমৰ্থন কৰে।
Means I
Yes.
am the guardian.
Miss N. Fukan, Learned Council, appearing for the petition, for the Learned Standing Council, Elementary Education Department has placed on record a communication dated 9/4/2024 issued by the District Elementary Education Officer, Kolkata, wherein in response to the queries raised by this court, it has been stated that the petitioner's name, although nominated by the by the school authorities for appointment for nomination as president of the school managing committee of the school in question, the same was not approved on the ground that there was no children studying. No children, or on the ground that no children of the petitioner was studying in the school. And which was also stated to have been confirmed by the concerned headmaster of the school in question. However, the petitioner, by referring to annexures 2 and 3 to the writ petition, has demonstrated that the daughter of the petitioner, Sumaya Akhtar, is a student in the said school. Full stop. The district elementary education officer shall clarify as to the basis on which the instructions were so incorporated in the communication dated 9/4/2024 to the extent that the petitioner had no children studying in the school in question. The said instructions be placed before this court on 26/4/2024. The copy of the instruction dated 9/4/2024 as produced by Ms. N. Fukan is kept on record and marked as X for identification. Mr. Naik, you are appearing for?
Yes, sir.
Oh,
From the 1-3.
let them. Huh?
I have nothing.
Nothing.
Obliged, my lord.
No, no, no. এই 26 তারিখে। So disclosure.
Supplementary course list, motion item 34.
Thank you, Lordship. Lordship, the receipt petition against the Lordship, dismissal of the petitioner from the service.
Show me how a writ is maintainable.
Lordship, in respect of.
Federal Bank case.
Lordship, in respect of Lordship, I mean, Lordship, to judgment of the Supreme Court, Lordship. One is Lordship 1989, 2 SCC, Lordship 691.
What is the name of the party?
Andi Mukta Sadhguru Sri.
All those gone. See Federal Bank. Then latest judgments, St. Mary's School, not maintainable. It may be having a public character, but your relation here has got nothing to do with the bank's public's. Is it statutory? Is your service condition statutory?
No, Lordship.
Then right from Federal Bank and the second judgment?
Second judgment was G Telefilm, Lordship. Lordship.
There are direct
Lordship.
judgments. So this is not maintainable. We'll
Lordship, can you see the conduct, Lordship?
how can I when that it's not an authority? Show me that it's a state. Either within the meaning of Article 12 or other authority within.
Lordship, I beg, Lordship, this Andi Mukta, Lordship 1969, Lordship, this is the Lordship, judgment, Lordship of
Okay, you cite your judgments.
Lordship. Already cited, Lordship.
You want to cite
1989, Lordship, 2 SCC.
1989?
Lordship. 2 SCC. 691, Lordship.
Okay, then another one.
2005, 4 SCC, Lordship. 649, Lordship. Lordship, paragraph 20 of the Lordship is this 1989 judgment, Lordship.
Paragraph 20.
20, Lordship.
Hmm.
May I read, Lordship? The term authority used in Article 226, Lordship, in the context must receive a liberal meaning. Unlike a term in Article 12, Article 12 is relevant only for the purpose of enforcement of fundamental rights under Article 32. Article 226 confers power on the High Courts to issue writ for enforcement of fundamental rights as well as non-fundamental rights, Lordship. The word any person or authority used in Article 226, Lordship, are therefore not to confined only to the statutory authorities and instrumentalities of the state, Lordship.
Fine. Show me the action that they have taken against you.
They may cover any other person or body performing public duty, Lordship. The form of the body concerned is not very much relevant, Lordship. Where it is relevant is nature of the duty imposed on the body, Lordship. The duty must be judged in the light of positive obligation owed by the person or authority to affected party. No matter what means the duty is imposed, if a positive obligation exists, mandamus cannot be denied, Lordship.
This was considered in 2003, 10 SCC 733. This decision.
And this decision also relied upon also with this G Telefilms.
There is no dispute that it may have a character. But when it's a dispute between you and the bank, whether that is statutorily under some statute that is prescribed. You read 2003 10 SCC 733. Para 33 and 34. Right? And thereafter read 2023 4 SCC 498. And come back at 2.
Can it be on Saturday?
No. We were about to dismiss this matter on the last occasion. You did not appear. So give you an opportunity, we had fixed this matter today. 2 o'clock. Hey, 2000
Item number 31.
Hmm?
It's on admission, item number 31, my lord. 21. Huh? 21.
31, Hare Krishna Monto, no.
No, 21. Sorry, 21, my lord. 21.
Avinash Kumar.
My lord, perhaps he would request.
What?
21, Lordship, even I have not seen the file also.
You need not, I have seen it.
My sister has appeared.
I have seen it, be here.
Difficulty is
That RT JCO, you be here. It will be called up, you be here.
And particular this case, my brother's case, Lordship, latest judgment UCO Bank, 10 April, Lordship. 10 April, Lordship.
That is the beauty of Mr. Gogoi.
10 April.
Give him.
I will provide.
And then you decide
10 April.
whether you want a dismissal order or a withdrawal order with liberty to approach the appropriate forum. I'll give you that liberty. Otherwise, you don't
10
have.
April, Honorable Three Judges Bench of the Honorable Supreme Court clearly was.
St. Mary's case is very clear.
10 April.
There is a
also-
distinction between an authority, definition and authority, and when it is an action between the employer and the employer, Federal Bank and these two. That is the distinction it has made. Give him that citation.
Lordship, 10 April. Lordship. It
And
said-
Avinash Kumar, what is there? Nothing. We'll dismiss it today. You be here.
If Lordship, a St. Mary's judgment, Lordship, that is paragraph 68, Lordship.
Therein, Federal Bank has been discussed.
Yes, Lordship.
And it said you have.
But specifically, Lordship, in a St. Mary's judgment, Lordship, service matter of the private.
No, I'm not on that. I am on the point.
Of
Federal Bank-
maintainability, Lordship.
Federal Bank is a bank.
Bank.
And you will find similar judgments with regard to IndusInd Bank also.
Yes, Lordship.
So this is not maintainable before this court. You withdraw it, I'll give you liberty, you can approach any other forum wherein you can. Your name?
B. Malaka, Lordship.
Mr. B. Malaka, Learned Counsel for the petition. Full stop. Mr. B. Malaka, after advancing his argument for some time, has finally phrased that he has finally, on a query being put by this court, as to whether the writ petition would be maintainable in the matter, in as much as the same is so instituted with regard to the action taken by a private bank. Mr. Malaka submits that he be permitted to withdraw the present petition with liberty to approach the appropriate forum. So, where accepted, the writ petition stands dismissed on withdrawal. Both the dismissal of the present writ petition shall not bar the petition from instituting appropriate proceedings before the appropriate court, appropriate forum, as would be available for the dispute as involved in the present proceedings. You can take this. You can use it. Yeah, but
Timing 18.
yes, Mr. Nim, what is the position?
My lord, on last occasion also I obtained the instruction, my lord, after filing of the writ petition, my lord, he was offered promotion to the post of junior division assistant at Lakhimpur, my lord. But he refused to join
How
there,
can you offer him at Lakhimpur?
my lord, because
This is not a state cadre, this is district cadre.
but my lord, that junior division assistant, that post was at that point of time available was at
How can
Lakhimpur.
you give him a posting in Lakhimpur? That will be barring people there.
No, my lord.
It's a state cadre. It's not a state cadre, it's a district cadre post.
Yes, my lord.
Joint director,
Yes, my lord.
directorate is this.
Yes, my
How
lord.
can you? And why did you promote those people without considering his case?
My lord, because on last occasion regarding the present status of the petitioner, regarding that I obtained instruction, my lord.
But you have not filed a written statement. You will accept whatever the petitioner has said. We will not direct
No, my
that you
lord.
promote her
That
from that date.
My lord, on that day when I produced this instruction, they have not denied this instruction, my lord.
Forget it. That is subsequent. In Lakhimpur, he may not be interested. But when there was post in Sonitpur,
But
Pre-post.
thereafter, he has not ventilated his grievance any further, my lord. After that, my lord. Because, my lord, when he,
Mr. New, that is an action after the institution of this proceedings.
yes, my lord.
We are concerned with issues which are there leading to this proceeding.
Yes, my lord.
And leading to this proceeding, it is apparently clear, in absence of any counter, either by you or by the respondent, private respondent,
Yes, my lord.
that she has been deprived.
My lord, but when I produced this instruction before your lordship, my lord, on last 2-3 occasions,
Mr. Niyog, Mr. Bora, sorry,
yes, my lord.
you clarify how he can be promoted in Lakhimpur.
Yes,
That is beyond his cadre. You cannot.
yes.
And tell me why the case of the petitioner was not considered when in 2013, person junior to him was promoted. This is not called for.
Yes, my lord. So regarding that, I will.
So if you like somebody, you will promote them. We'll draw that conclusion. We will draw that conclusion that you have promoted the private respondents because they were close to somebody. And he was ignored, although he was senior.
Yes, my lord.
Tomorrow, have that instruction.
Tomorrow,
2
my
o'clock.
lord, my
2
lord,
o'clock.
on Tuesday or next Monday, my lord. Because, my lord, it is a old matter, my lord. The records have to be dragged down. my-
People are still there. Ask them.
No, my
The
lord.
private respondents are still there.
I do not have any contact with the private respondent.
No, your officer can ask them.
Yes, my lord, but official respondents, my lord, they are also new. So only on till Monday, my lord, because it's an old record, my lord. Even we do not have our record, my lord.
On the prayer of the Sadhiki Bora, this matter again on 23/4/2024 as a partner matter. Mr. Bora on the next day shall apprise this court, shall apprise as to why the private respondents were considered for promotion to the post of junior assistant in the establishment of the Joint Director of Health Services, Assam, Sonitpur, ignoring the case of the petitioner herein who contends to be senior, the said three private respondents. Mr. Bora, on instructions, has today submitted that the petitioner during the pendency of the present proceedings was offered a promotion to the rank of junior assistant at available against a vacant post available at Lakhimpur. Mr. Bora shall also apprise this court as to whether the cadre, whether the ministerial staff in the district establishments form a independent cadre and or as to whether the ministerial staff in the under the Director of Health Services Assam form a single cadre all over the state, although they are working in district establishments.
My lord, a copy of this order may be.
Download it, we'll upload it today. Might be have to-
Obliged, my lord.
Obliged.
You have it on, we'll give you one more day. We'll have it on 24th.
Yes, my lord.
24th, go ahead. 24th, go ahead.
Obliged, my lord.
But get me that instruction, otherwise we are going to direct for a promotion from that day.
Yes, my lord.
Then you will be responsible
Then, my lord,
with interest payment.
any of the private respondent will be.
That is up to you.
affected.
That we don't know.
Yes, my lord.
Because service
Because
of
the-
notice is complete.
Complete, my lord. So if
You will
they,
promote him from that day with interest.
yes, my lord, if the private respondents are not appearing, my lord.
Give me a cogent reason as to if there is a valid reason for not promoting her, fine, no problem. We will record that and we'll dispose of the matter.
Obliged, my lord.
Admission item 21.
Battle without an adversary, my lord.
Huh?
A battle, it will be a battle without an adversary, my lord. He does not have the brief.
He need not have. we have 2 advertisements. Second advertisement, you are directly out because of the corrigendum. First advertisement, your statement in paragraph paragraph 4, that you also were responsible for change of your cadre. Trade.
Yes.
So if that be so, RTPC, RTJCO, there was no post in Himachal. How can you be? But they considered you as an ORL. They considered you as ORL and they found that you are lower in merit.
Having subjected me to the written test of the RTJCO, can they?
There was, you can't, that is your own creation.
But there
is no post. There is no post of RTC.
When they say that the post will be transferred, there are vacancies.
No.
In fact,
You can't establish the statement, Mr. Majumdar.
Their letters say that they entered me erroneously as an RTJCO. I had to go through it.
And they have also said that they rectified that.
They have rectified it after I have given my written test. So, if they had allowed me to go through the ORL and not done the mistake, I would have participated in the selection process of the ORL. Whereafter they could have.
And they have allowed you written examination. I think it was 1.
No, written examination for RTJCO, not for ORL. How can they consider my merit in the ORL to bring me to a medical test?
Can't help it. You are also responsible for that. And that is further fortified from your subsequent application. You wanted RTJCO. You managed that. Allegation can be made. And they have made that in their written statement also, fraudulently.
Fraudulently is something they come up with now because it is the same person who has given me the rejection order. The same as Rajan is writing.
And you have not made him a party respondent by name yet.
Who?
The person who motivated you purportedly to apply.
They admit that someone had motivated me.
No, they say you have.
How can I?
You have.
A recruiting officer, my lord.
And you have.
A recruiting officer, my lord, would not be.
And he does not have a power to do that. In the field, that recruiting officer has no power to change your trade.
What they admit is.
And see, Mr. Majumdar, in their affidavit, they bring on record 2 documents. One, by which you were communicated that, see, these are the reasons why you will not get it. And second, a document saying that you don't come within the merit position.
Yes.
These 2 documents are prior to filing of the writ petition. You have not brought it on record.
Whether that is.
You come to page.
That is there.
29?
That is there.
No. You come to page 24, 25, 26.
Page 30, Lordship will find. I've given that. The communication which was given to me at my address, I've given that. Page 30.
Page?
30. Of the writ petition. That is fine. Letter dated 25th of September 2013.
Okay.
It is there.
Page.
Annexure P11.
P11. Page 30.
27 is struck off and made.
30 is something else here. 15/4/13 advertisement.
Hello? 1 page prior to that.
29.
20. That letter is there. That communication that these are the reasons.
But this is not under challenge.
No, this is the reason that this is the reason I am challenging my disqualification itself.
No. Mr. Majumdar, they have set some reason here.
They have
Have you
said
dealt with it?
your name was erroneously entered as RTJC.
Forget it.
That is what
They
I'm
have said
challenging.
XYZ here. Be that as it may, they have said XYZ here. Now, where is your statement?
Yes.
with regard to annexure I.
And yes, para 8.
Read it. Second paragraph, the second line, the second part, page 8.
He allowed a chance for the medical test of oral trade. The petitioner refused the said offer and further stated that RTO JCO post for the Himachal Pradesh was not available. My lord, this is perhaps a typing error. Lordship will find in the others in the applications here said he was refused. That was part is not here. I had noticed it. I read the applications which my lord was prior to the
Now,
drafting.
show me the statement which you said
Was
that you lost a chance
yes.
for coming within the merit because you were not considered for that. Show me a statement.
For the oral my lord.
Oral.
That particular statement, my lord, I'll have to go through the draft. Should be there. I read it.
I could not find out. Maybe you can help me out.
Perhaps that is. His lordship will find it page 6. But the petitioner was not allowed by the authorities for the trade.
That
test by
is different
refusing
thing.
That his name was erroneously.
That is
entered in the
different thing.
RTJCO.
Where is that statement?
Yes.
Your argument.
Hello?
Your argument. Mr. Mojumdar, we
Because
know.
I was there in the.
You, Mr. Mojumdar, I know. But I want to know what Avinash Kumar is saying.
That lordship will give me some time. I'll have to go through
No.
every of the.
You do one thing, you go through it, we'll have it after a few matters. You go through it, we'll have it after a few matters. By the time Mr. Gogoi will also apprise himself. After a few matters, we'll take it up. Don't worry. Matter.
22.
Yes, Mr. Islam.
My lord, this case, my lord, the petitioner has been deprived from the merit of pronunciation, my lord.
Yes.
My lord, on Dhunira's
This case, my lord, we have not received any.
Not received any instruction.
My lord,
Okay.
here, name of the petitioner has not been recommended by the SLC.
He says that the person who has now been nominated, Rabha,
He has expired.
he has expired prior to the date. So you'll only have to consider
My lord,
whether he expired prior to 1/2/2021.
my lord, on the other also, my lord, he was junior to me, my lord.
Oh, that's a different thing altogether. How can we proceed against a dead man today? If he is dead, redo that exercise. He'll submit an appeal.
My lord.
And this appeal will have to go before the government, not before the director. Submit an appeal before the government. Okay, disposed of.
Second one is also, my lord, this.
Now, same, both are same. The second one, she retired.
My,
Some
Right.
time limit will be given, my lord.
Huh?
Some time limit will be given to government.
will.
Otherwise, my lord, they will-
Tuta disposed of.
obliged.
24.
23 was there, my lord.
23 also, both. That 23, she retired,
My lord.
right?
Obliged.
And 21, dead.
I am blessed.
But they will verify that fact. And thereafter, if it is found to be correct, they'll proceed.
Yes, please. Obliged.
Yes, that is also.
Madam, you are appointed initially in the ME school.
ME school as science graduate teacher
Okay.
on 38 December 1991.
Now, thereafter, this
Yeah.
school was amalgamated.
Amalgamated on 6th of June 2011, 17.
Now, just come to the rules. principal. Because Jagannath Pegu case, says that even if it is for,
But past service cannot be, my lord, your lordship also.
no, not on that. Jagannath Pegu says that even if it is for a temporary appointment,
Yes, my lord.
ad hoc appointment, you must fulfill the conditions which is required
Yes, my lord.
for
Yes,
regular
Yes,
appointment.
my lord. There is no
So
dispute about it.
Just we'll see the 2018 rules with regard to principal.
Regarding, my lord, teaching is only 1 point, my lord, clicking regarding 17 years of higher secondary school. Only 1 point. But, my lord, the amalgamation rule says.
No,
that he will
that
be arrested,
amalgamation
yes.
rules cannot
Past
do
service
away with this 2018 rules. You will have to comply with 2018 rules.
That is, my lord, regarding, my lord, school and division bench judgment is there, your
That is
lordship.
under the 2003 Act, not under the 2018 Act.
The principal would follow, my lord, that is discriminatory.
Show me.
The rules.
That is the only point you have, Mr.
Division bench. Page 580.
Moreover, it is a directed footballer. That is the
And madam, if I'm not wrong, the division bench judgment is with regard to high school and higher secondary school.
That is there, my lord, but my lord, amalgamation condition, it is stated, my lord, that.
You will get your seniority
16.
from that date if it is a high school. No problem on that. Nowadays, amalgamation, you get the science
Amalgamation
graduate teacher, you will be a graduate teacher.
My lord,
But just show me about
whether
this.
the merger rule ignored a.
Merger, from that day onwards, you will
Merger.
have the experience.
Then he had served, my lord, for so many years.
No. From the
30
date of
years.
merger, you will have
Yes.
that experience. But prior to that,
My
how
lord,
can we?
No, in the merger, my lord, whether the past service will be ignored. Because he has started as a teacher.
Not ignored. Not
Graduate
ignored.
teacher.
It does not say. It says candidate must have rendered 15 years of service as per. Yours is you are a graduate teacher.
Graduate teacher from the date of.
The candidate must have 17 years of teaching experience as graduate teacher in any higher secondary school.
Yes, it says so, rule says so. And my lord, the.
Now, without a challenge to these rules, how can you establish your case?
Yes, my lord, I'm following.
So I can't go beyond a 309 rule.
I'm following the my division bench judgment.
Division bench judgment, high and higher secondary transfer under the 2003 rules, right?
Yes,
This is 2018. It's a separate provision.
there's no.
Yes, Mr.
over this.
Kaushik,
But my lord.
what is your stand on this? What is the departmental stand on this? Admittedly, petitioner was an MET school teacher.
And
You amalgamated that with a higher secondary school. Forget that ME school will teach to 1 to 5, 5 to 8. Forget that. Now, when we have specifically concerned about a principal's post, Jagannath Pegu is there. It says you must have that. 17 years experience as a higher secondary school teacher. What do you say on that?
my lord, the rule is very specific in Rule 12, my lord, of the 2018. 17 years teaching experience as a graduate teacher in higher secondary school. And if the teacher has come from an ME school, amalgamated school, then he has for vice principal, he can. Because Rule 13, that makes a different distinguish between
Show me.
my lord. Rule 13, page 34, my lord. Rule 13, sub-rule 2D, my lord. In case of amalgamated high
Okay.
secondary school,
Okay.
the assistant teacher,
Yes, madam. Show me a way out.
13. yes,
We'll
my
ask
lord,
Mr. Roy to vacate that chair for you.
One discriminated rule 13.
Rule 13,
Yes.
vice principal. Specific provision for amalgamation. Maintain.
and Rule 12 my lord, makes a specific provision for vice principal. The teacher who becomes a vice principal, 5 years of vice principal, he becomes eligible.
Normally, my lord, they, for the, my lord, in-charge principal or headmaster, The senior most person is to have, if he has the qualification, my lord, then my lord, he used to take charge because it's a temporary admin. He's
I
the
am
senior
faced with
most.
a decision of this court in Jagannath Pit,
Jagannath.
following earlier decisions,
Yes, my lord.
wherein it says you must fulfill the criteria for regular appointment, even if it is for an ad hoc. And we have been passing orders on that.
My lord, I filed a written argument, but not having gone
Ah,
to the
okay.
written argument. And some decision also there, where my lord, your lordship was committed that my lord, the past service cannot be ignored.
We are not on that, Madam Chair. Your past service seniority, nothing is being ignored, but you don't have the qualification prescribed under the rules.
Qualification, my lord, only that 17 years.
That is one of
only
the
one
criteria.
point,
That is
only
one
1 point.
1 point. How can I, without a challenge being made to that rules, ignore that? Because I'll have to go against the rules indirectly. Otherwise, everything is clear. You are senior, you are everything is clear.
My lord, he has worked as a graduate teacher, 17 years. In my written argument, I have
But in
stated, my
any
lord,
school.
has the total teaching experience of the petitioner from the date of his initial appointment.
Yes, Mr. Kosik, anything more?
The registered ME school, along with the teaching experience after the amalgamation of the school with a higher secondary school, the petitioner meets the requirement of 17 years of teaching experience.
But
as a
that
graduate
cannot
teacher.
be taken up at least for the post of principal. Because you see the distinction in the rules 12 and 13. It makes it apparently clear.
Yes, clear, my lord.
Who is holding the post now? You are holding.
No. Inspector is holding.
Inspector is.
Inspector of schools. You have filed a vacating application.
Gazette teacher only one makes it discernible that the assistant teacher in an amalgamated higher school would also be a graduate teacher if the qualification for such. I'm just few lines I'm reading, my lord.
You're reading from?
Would also be graduate teacher in the qualification.
You're
I'm
reading from?
reading from first, my lord, I'm reading from an order passed by this honorable court on my lord 3rd of October 23. Honorable
Yes.
Justice Bujar Borwa. From his my lord, paragraph 2, that petitioner is an assistant teacher in the SLM school prior to amalgamation, and it stated that the petitioner had also acquired a graduate degree even prior to his initial appointment in the ME school in the year 1991. The petitioner raises a claim that by virtue of being an assistant teacher in the ME school and having a graduate degree, even
Madam,
prior
is it a higher secondary school or high school?
higher secondary.
High secondary. Okay, then what does it say?
No, that is an order which is passed in this repetition.
In this case,
In this case,
repetition,
where?
an instruction was obtained.
only in this.
So they did not file any affidavit, my lord.
No, our
Order
affidavit is
dated,
there.
order dated?
Order dated 3 October, 3rd of October 23.
3rd of October. Hmm.
Kosik submission also recorded. Regarding 70 years experience after the amalgamation of the school with a higher secondary school. The petitioner meets the requirement of 17 years of teaching experience as a graduate teacher. In the circumstantial question for determination will be as to whether the petitioner having the graduate qualification and being a teacher in a ME school is a graduate teacher under the law. The expression graduate teacher is defined under so and so, so and so. And the definition of graduate teacher as provided under Rule 2 of the Rules of 2018 would make it discernible that if the post where the teacher was appointed at the time of appointment did not have the minimum qualification of being a graduate, such teacher could be a graduate teacher under the rules. It is submitted by Mr.
I
Kosik.
give you a reply to this. The 2018 rules mandate that you are a graduate teacher. But when it
Yes,
comes
I
for the question of promotion to the post of
Principal.
principal, there is a specific criteria prescribed. Otherwise, you can be the vice principal. You can, I think, even be the headmaster.
And to
So the
the
definition, my lord, that submit,
Apart
was
from
my
this-
submission with regard to Rule 12 and 13 on that day. In fact, the definition of graduate teacher in the 2018 includes the amalgamated school. So that is no more.
Madam,
Yes, my lord.
You can just come to Rule 14(2)(b) and see the wordings.
14.
Ten years of teaching experience as graduate.
Graduate teacher. Simple.
The post of assistant headmaster shall be the filled up by promotion to the candidates among the cadre of graduate teacher on the basis of high school seniority list on the recommendation of the selection committee. The selection of assistant teacher shall be made on the basis of seniority, merit, and satisfactory annual comprehensive report.
You're reading?
14.3, my lord.
No, 14(2).
14.2.
Hmm.
The post of headmaster shall be filled up by promotion from the candidates among the assistant headmaster and the cadre of graduate teachers on the basis of school-wise seniority list on the recommendation of the selection committee. The selection of headmaster shall be based upon seniority and satisfactory annual conference report for last 3 consecutive years. But my lord,
13(2)(b).
this is
14(2)(b).
14.2.
Even the proviso to this 14(2)(b), my lord, makes again distinction for the amalgamated teacher. So this amalgamated ME and ME school teachers were brought
Headmaster.
under the purview of promotion also.
For
Provided-
headmaster, vice principal, assistant headmaster, you have come in. But for principal, you are not there.
Yes.
Unfortunately,
But-
that's the scheme of the
As
rule.
principal, no, but in the school,
That is
in the school.
cost saving
that-
measures.
But your lordship passed some judgment, my lord, regarding, my lord, that but another school, my lord, I have filed an additional affidavit, reply to the affidavit. Dear, my lord.
Ah, you have brought on record a order. I've seen that.
Yes. That is
One,
there, my lord. That is there. I have filed on it. Here, my lord, the another school, ME school, Maharaj, my lord, he has been appointed as headmaster, my lord. That is on page,
Page 137,
Yes,
Abdul
ma'am.
Wadud.
yes, my lord, Abdullah.
But that cannot give you a right. Yes, what is the order you wanted to rely on, those courts?
Yes, my lord. With your lordship judgment. Yes, the requesting it. I have stated in the written argument, my lord. And the judgment are Sanjeev Shekhar Bhuya and my lord,
A.R. Bhuya's case. Mr.
One
Advocate is
is
Mr. A.R. Bhuya.
but yes, yes,
Ah.
yes, Bhuya's case.
That
Already school and secondary,
two
yes,
provisions, how to read it together. I
Yes.
think that's the case. I think he is a principal.
He is a principal.
Ah,
Post
ah,
of
ah.
principal, my lord. Whether he can apply, that is for application.
No.
He filed the
Just,
case for application. You
Just show me the
lordship
judgment, I
or
forgot.
Yes, I can do. Yes, I can do. And this also accommodation. Parallel just section the one of judgment. I can do this. There he was not, he could not apply, but my lord, due to your lordship judgment, he has applied, my lord, for the post of principal. To see
No,
to the
madam, there is a
selection
difference here. He was recruited as a graduate teacher, if I'm not wrong.
committee.
Graduate teacher, he continued.
Continue in the high school.
Before even joining, he had also applied for postgraduate teacher.
Yes, ma'am.
Subsequently, he was appointed as a postgraduate teacher.
Yes, ma'am.
So as a postgraduate teacher, he had not completed 15 years.
Yes, ma'am.
So they were not considering.
Yes, ma'am.
But taken together, he had more than 17 years.
Yes, ma'am.
This court, I think this
That
court,
my lord, that's high school and my lord, this PG.
for graduate teacher and postgraduate teacher, we directed, take it together and then proceed.
Yes,
But your case does not fall in that.
my lord, as a graduate teacher, my lord, I have.
He was
completed
working in a higher secondary school only, but in a graduate post.
graduate.
Subsequently, he became a postgraduate. If I'm not wrong, that's the
The
case.
difference is there, it is. I have
No appeal on
your
this.
lordship, my lord.
No appeal.
I'm not sure.
Yeah, my lord, actually the teachers in the division bench, they have selected all the teachers were, my lord, from high school and higher than school. ME school, that time, my lord, the occasion did not arise, my lord. Now, my lord, if somebody selects.
The petitioner admittedly had rendered continuous service initially as a graduate teacher, then as a postgraduate teacher in a higher secondary school, and no dispute in this connection exists. Mr. Sharma had appeared. You, Sharma. Then we have heard that in considered view of this court, given the manner in which the provisions of Rule 12 had been structured, more particularly the provisions of Rule 12.3.2 and 12.3.4 thereof, the same cannot be read independently and must be read conjointly, inasmuch as both the said provision mandate possession of a particular length of teaching experience by a candidate concerned, for being considered for appointment as a principal of a so-and-so, and given the teaching experience garnered by the petitioner, he must be held to have satisfied.
The intention of the division bench was that, my lord, that will be discriminatory. But, my lord, the ME school, my lord, they did not approach, my lord. If, my lord, it would be a graduate teacher in ME school or along with the high school, they should have
Anything more?
considered, my lord.
I think that's the issue. I think you will have to challenge the rules, ma'am. When the rules existing, I'm sorry, I will not be. I was going through, so I was trying to understand your challenge.
I have done the homework, but there is.
But maybe before a understanding court.
Sometimes, my lord, no option left what to do.
I'm only on that point.
But, my lord, we are free to,
Because
my lord,
that is the crux of the matter.
Yes, ma'am. Only that
Mr. Roy, anything more?
17 years. He is willing, man, so there is no.
I was searching for this judgment. Thank you, you gave it to me. That day I wanted it for something, but I was not able to. Because I'm so techno savvy.
In paragraph. the
Mr.
division bench,
Kaushik,
paragraph
I'm so techno savvy that I still require paper. We are closing it, ma'am.
Yes, ma'am. No elect. Yeah, my lord. Yes. But
And while dictating, if we get something in your favor, don't worry, we will go through that also.
25.
Judgment.
that is also another judgment of our lordship. It is admitted position that the respondent had been appointed initially in high school as a headmaster during the period when the said school was in Hansa stage. Thereafter, the respondent authorities, upon consideration of all materials, had provincial as the service of the your lordship judgment. The respondent for head number so and so, therein the service of provincial as a headmaster, and he was authorized the scale of the so and so, so and so.
What is the name of the party, ma'am?
Name of the party is, my lord, Human Gogoi. Human Gogoi. Human Gogoi versus State of Assam.
Just
Lordship
let me see.
judgment is of 12/12/23. So dear also, my lord.
That is
Lordship has
the
given
initial
good
period I
understanding.
was.
The paragraphs are really very good, my lord, good understanding, but my lord, in view of the matter, for decision regard to the case in hand, pertaining to holding the post of headmaster of Kamargaon so-and-so school, it is immaterial to consider the submission of petition that this aspirant of is not eligible to hold even when he is not passing the B.Ed degree. In fact, as immunity in the present proceeding also, ratio so-and-so, 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 regular income of the category. In view of the result, I am of the considered view that the order dated so-and-so does not call for interference and came accordingly maintained. The interim order passed earlier so-and-so, so-and-so, shall now function as the headmaster of Kamargaon Tribal High School.
Just for me, ma'am. I can just recollect. Yes, Mr. Sharma? What is here?
April file, my lord.
Oh, you appear.
That task was directed to be maintained by an appeal.
Hmm?
Appeal
The
has
task-
been filed against them.
Huh?
Appeal has been filed, my lord, against them.
Okay.
One more thing, my lord. She has also not completed as graduate teacher, my lord, 17 years.
Not
Because she
completed.
has part in 12-13. It is 10 years now, my lord, of passing
We
graduate.
will say only by following.
Correct.
Huh?
It's not correct.
You have completed.
passed-
Yes, yes, bro.
17 years as graduate teacher, she has not.
Equivalent, there are decision number.
17 years.
That
she
we
has
will
not
leave it to
completed.
the director. Director
Yes,
will look
director,
into.
yes, ma'am. Because he says passed in 14, my lord, so it is 24, how she can complete it? 17 years of service. Both the persons are not competent.
Okay.
And they have,
He was provincialized as a headmaster. So this court held that BEd is not required.
in my case, only.
12. Very new at that point of time.
But you are very experienced, my lord.
No, no.
Service matter and
No, no,
all
no.
this matter. I believe your Rachi is very much.
Let me know
experienced.
what happens here. This will have some bearing. Appeal.
Directed to maintain status
Huh?
quo.
Huh?
Directed to maintain status quo. In the appeal.
Director to maintain status quo. Itu move DD question. Itu are by do aro ta decision. Itu does husband move DD question. Move DD. Thank you, ma'am.
All right.
We'll pass on this.
But my information only recorded, I have given the affidavit reply.
I'll
She has graduated in 13-14, my lord.
Okay.
14 is Johnson.
We
So 17 years she has not.
we will direct the with the
Director, my lord.
director to look into the matter.
All right.
We'll only say you are not eligible, and as to
Yes.
who would be eligible,
That
the director will strictly apply the provisions of Rule 12 and thereafter find out.
All right.
25.
Morning, my lord, I have mentioned this matter on behalf of the.
Yes, why are you not filing an affidavit here?
We have not received instruction.
Huh?
We have not received.
Why? This matter is pending from June 2023. Still now, 2-3 days.
Well, I need some time, my lord.
How much time? You give me, I'll give you. 2 weeks. Mr. P.K. Bora, Learned, Standing Council, Elementary Education Department, undertakes that the affidavit on behalf of the said respondent shall invariably be filed on the next date of listing. Full stop. In the event it is not possible to file the affidavit for any reason, comma, the written instructions as may be required shall be placed before this court from the respondent authorities. List this matter after 2 weeks on a date to be fixed by the registrar. So that I did not adjourn it because at least it can get somewhere.
God bless.
No, no, check with you.
26.
Yes.
Petition. Challenging termination. from
Naturally,
service.
you have challenged, but where is that affidavit? Or you have giving it a walkover? We'll say non-traverse or things have been accepted. Yes, Mr.
That's what probably they've got nothing to say.
Oh, that's it.
Yes. And obviously they'll have nothing to say here.
Yes, Mr.
Sometime,
Some
What
more
do you
time-
say?
Some more time. my lord.
When? You ask, you tell me, I'll fix it. But on that day, if I don't get it, difficult.
After 1 week, my lord.
1 week. Okay. 1 week. On the prayer of Mr. B. Talda, Learned Standing Council, Secondary Education,
Elementary education.
Elementary Education Department, list this matter again on 29/4/2024. Mr. Talukdar undertakes to place on record by the next day the affidavit on behalf of the respondent authorities, state respondents, and or in absence of filing such written affidavit, to place on record the detailed written instructions pertaining to the challenge made in the present proceedings. Right?
Township, in case they miss it,
Let them. 23 meter, let them. It's a Talukdar.
My
Have you
lord.
heard the order? Should it go like that? Huh? Okay.
27.
In this case, my lord, I have received the instruction, my lord.
What is it? No. This is not my query. My query is, how is a non-provincialized man allowed to be the headmaster of a provincialized school?
This is, my lord, now, my lord, they have provincialized, my lord, petitioner, my lord.
Provincialized?
No, my
When?
lord. As per my instruction, my lord, the name of the petitioner invariably is left out, my lord. So the director wrote the government to re-verification and
You do whatever you want to do. How can you post him as a principal, headmaster of that school?
my lord.
Or is it that anybody can be done? If that is the stand, tell me. Why should I break my head? Huh? You are still holding the charge.
My lord. Actually, my appointment is a headmaster, my lord, in the Hampshire state, and I also got.
So you accept that anybody in a provincialized school, even in a venture stage who was there, he can continue, whether provincialized, non-provincialized, nothing. No problem.
So this instruction.
That is the instruction.
Next page, my lord, report of the. Please report the government, my lord.
You forget that. You do whatever you want to do with
Get
this
it.
case. But why is he allowed to continue as the headmaster without? Where is that order? Headmaster? Permission to continue as headmaster. Where is that order?
There is no such order, my lord. My appointment is in the. There is no such order passed by the, my lord, the department, my lord.
Who allowed you?
My appointment is a headmaster, my lord, and.
No. You are in the venture stage. You're not provincialized.
No, provincialized. That's why I'm.
You are signing the bills and all.
My lord, he has allowed, my lord, and there is no interference, my lord. And in the initial state, this honorable court also passed an order, my lord, to maintain the status quo, my lord. But there is a
Where?
later stage, my lord, in the first order, my lord. And so far, my lord, provincialization is concerned, my lord.
But that is with a clarification.
My lord. And the school is more than, my lord, 100 students, my lord. From the initial.
No, I'm nothing. You get yourself provincialized, you become the headmaster, I have nothing to say.
My lord,
But how can you be a headmaster in a, your services are not provincialized? Yes, Mr. Talda. Is it permissible?
No, my lord.
Then,
On that query, my lord, I have to take instruction.
you do the remedial measures, come back to us on Tuesday. Mr. B. Talukdar, Learned Council, Learned Standing Council, Elementary Education Department has placed on record a communication received by him from the dated 17/4/2024 received by him from the Director of Elementary Education Assam. A perusal of the same briefly reveals that the queries as raised by this court-wide order dated 1/4/2024 has not been answered. Full stop. The query of this court was with regard to the issue as to whether a teacher not provincialized, a teacher whose services have not been provincialized, can be allowed to function as the headmaster of a provincialized school. The said aspect has not been answered by the departmental authorities. Full stop. List this matter again on 24/4/2024. Mr. Talukdar shall place on record specific instructions in this connection as sought for, while the order dated 1/4/2024. The respondents are at liberty to take remedial steps in the matter as may be called for. A copy of the communication dated 17/4/2024 as furnished by Mr. B. Talukdar, Learned Standing Council Elementary Education, is kept on record and marked as Y. Okay? You check up if it is the law, if it can be done, we have nothing to say. We'll allow him. Why him? We'll allow 10 others also. Wherever there is a provincialization made, we will say whoever was the headmaster, he will continue.
28.
Lordship, here the petitioner's case were considered under the 2011 Act, Lordship, and it was only the director also considered
Show
eligibility
me
of
the government
staff.
sanction.
Lordship,
Show me the government sanction order for posts and salary.
government sanction, yes, Lordship, for sanction it was forwarded, but they have not taken any
By
action.
the
on
time
this
the act
matter.
goes,
No, Lordship, there is a judgment of this honorable court, Lordship.
Dilip does.
No, Lordship. There's another judgment. WBC 467/2020.
Show me, I'll follow that. Don't worry.
Yes, Lordship. Covers with repetition, Lordship, my case also. This one from para 3, Lordship. This is cited judgment.
Yes, Mr. Kaushik,
Para,
read this. If this is the thing, we'll follow this.
yes, Lordship.
10/4 is not required.
Because my name, the staff, name of the staff of my school also, Lordship, it is included in the schedule. And as per this judgment, Lordship, if names are included in the schedule, Lordship, they are eligible for provincialization, whether 2011 Act is.
None of the teachers in the school have been provincialized.
Yes, Lordship. The last page, Lordship, page 46. This is the schedule, Lordship. Page 46.
Come to the 2011.
Yes. 10-4. As per 10-4 lordship, it, after DLC will forward it to the, director for consideration for scrutiny lordship. And in my case, the director has scrutinized this, list and approved it. Only the lordship sanction for creation on, fund lordship, this was, remaining law.
Tell me how to ignore that. Just show me a way out to ignore it. I'll
Already-
ignore it.
Already they were selected,
No, 10-4.
10-4, yes. Yes, 658.
Hmm.
10-4. The district scrutiny committee shall forward the verified list of eligible teachers school-wise in accordance with the number of posts specified in the schedule appended to this act to the concerned director, who shall, after making such further scrutiny as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institutions and employees eligible for. Yes, only notification part is remaining.
No,
lordship, and it
This is not that notification. This notification is prior to a notification under 4.1. Once this is issued, 4.1 notification, if it is not issued, this court said, nothing doing, you are provincialized. Dilip does. But here, that stage in your case did not reach. How can we now require the government to provincialize you under 2011?
because this.
You are entitled under 2017 to have your cases considered, but not 2011.
As per the order of this honorable court lordship, they were considered and
Did you approach this court before this?
yes, lordship, in 2015.
Where is the order?
This lordship. Before that also, we have filed a miscase lordship. Page 31.
2013.
Yes, 2013 lordship. Page 29. Lordship, initially, what happened, after DLC approved our case lordship, two teachers approached this honorable court claiming.
Yes, Mr. Kaushik, what to do?
This is case 29.
In this order also, my lord, the interpretation of 4 and 10-4 was only in respect of the administrative order not being passed. But that has not been decided that whether this procedure of 10-4 has been followed-
Done away with. That is my case.
Well,
Otherwise, this, my case, is covered by this.
You will have to cross that barrier of 10-4. Or the stage of 10-4. Then only 4.1 is an administrative order, that's a ministerial order.
Yes.
Yes.
Even if it is not issued, this court can deem that you are already provincialized. Because posts and all were created for you. Here it's only a proposal. It has to go to the finance department, it has to come back. And thereafter the government will notify. And then the director will issue an order under 4.1.
But as per this judgment also, only if 4.1 is complied with, then they are eligible.
That we will give reasons.
Yes.
We will deal with that judgment, no problem.
Yeah.
Close it. 2017. Or you just wanted disposal, that this is not maintainable, I'll say. I'll not say anything else.
No, lordship. They are waiting for, since.
That's what I'm saying. Why keep this matter pending?
Eligible.
You first came in 2013, you waited till 23 to come back again. 10 years gone.
Yes, and they were.
Now
found-
this matter pending, they'll not consider your case.
Lordship.
and in fact, my lord, in
2013
Supreme
itself,
Court
they were
judgment in
found
R.R. Kishore,
Hmm.
CBI versus R.R. Kishore, my lord. Now this prayer developer, they cannot even ask for this. Because
Once the act has gone.
The act has gone.
It is their lapse lordship because at.
Anyway,
So that.
there was an earlier direction when the act was alive,
Yes, lordship,
and then there was some processing made.
yes.
Unfortunately, it did not take place. Only that judgment you are relying on?
Yes, lordship. Otherwise.
Copy to Lulu. Copy to Lulu at 21. Dispose of.
Dilitas is also sorry, on the same line.
Huh?
Dilitas also same line also. If the process is.
10-4.
Yes.
10-4. We can't ignore a statutory provision. If that we ignore, our judgment would be per inquiry. Other thing. Dispose of. No? Sorry. Next time.
That's it. They will be considered lordship.
Under 2017. Mr. Kadir has the same problem. This court directed 2017, now he is on review.
I have one delete as well, but then for it come back, district level committee.
Tell me.
Recommended.
10-4. Where is 10-4?
Yes, my district level committee, my lord, recommended, my lord, page number 39 of my.
State level, district level.
District level.
Then it should go before the government. Director.
Director forwarded mail to the government, my lord.
Show me the consequential order of the government. Creating posts.
No consequential order, my lord, is pending before the government.
Then.
As on date.
Rightly so, 2017, you have been asked to be considered. How can we flag a dead horse now? Flog a dead horse. There is a big discussion going on. Yes.
Check, my lord, there is a judgment of my lord Justice Ujjwal Bhuiya, my lord. In this context, that 10-4, it has to be followed, my lord.
Show me, give me.
My lord, it is 2016 1 ZLR 757. my lord.
2016.
1 ZLR 757.
Para. Para, name of the party?
My lord, it is Deepak Kumar Das versus State of Assam.
This was, I think, never relied upon.
This was not reliable.
So at least our tentative opinion is not wrong.
My lord.
Who found this out for you? Gogoi or Majumdar?
Mr. Majumdar. Both Mr. Gogoi.
Mr. Gogoi, give me that UCO Bank citation.
29 for order.
And whenever such new citations come, give it. And provided if there is a case wherein Mr. Majumdar is appearing, then the most welcome. Yes, Mr. Kadir, what to do?
So, my lord, 10-4, as per 10-4, the director, my lord.
We'll forward it to the government and the government will sanction and notify.
Yes, 10-4, my lord, notification, for issuing notification in respect of the positions of an employees. But 10-4, my lord, till the forwarding to the government, my lord, but what the government will do, 10-4.
Same to the concerned department of the state government for consideration and for issuing notification in respect of eligible institution and employees eligible for getting their services provincialized. So, director will send a list to the government.
Yes, sir.
Finally, it is the government who will do it. And how the government will do it? It will send it to the finance department,
Yes.
get that post cleared,
Yes.
and then issue a notification.
That part is pending.
And even if thereafter your services are not provincialized, you come before us, the judgment say 4-1, notification is not there,
Yes.
it's not a bar. You will be under 2011 Act. But before, without 10-4 taking place, how can we?
But my lord, in 10-4, there is nothing about the government's part, my lord, for the government's.
Yes. Shall forward the same to the concerned department of the state government. For what? Read.
Director
for consideration.
Yes.
And for issuing notification. So government will consider and issue a notification. So there is an exercise left. Consideration cannot be in air.
Yes, government did not consider pending, my lord. But the director's part is, my lord.
Director's part, we are
Director forwarded, my lord.
We have got it. And that's why this court said 2017. What mistake, Mr. Karim?
But my lord, in the earlier order, my lord, this aspect is not considered.
Which one?
11 in my earlier order of the
It need not be.
of this honorable court, my.
The final conclusion is you're not eligible under 2011. Now in a review court, why should I? That should be an appeal. If it's an erroneous decision,
My lord, page number 57 of the order, my lord. I have
57.
challenge, page 57, my lord. There is nothing, my lord, consider 2011, why not considered, my lord? There is nothing, my lord, page number.
And see, Mr. Kadir, this order is of 19.
Yes.
And you have come now.
Yes, my lord.
Why?
My lord,
Why should we entertain that on that plea also?
yes, my lord, there are some lapses on the.
Not some.
petition, my lord.
Not some. If you had a grievance, you had a grievance as of 28/8/2019,
Yes, my lord.
right?
Yes, my lord. It is, my lord.
So either accept 2017 or file an appeal. Right?
Okay.
Review jurisdiction is too constricted.
All right.
It will dispose quickly. Eyes up.
Time being 21.
Yes, you got that statement.
My lord, no. Lord Supreme at page 24 of the affidavit in opposition.
Affidavit.
Affidavit in opposition, page 24. If I may use your term, my lord, last nail in the coffin. Para 3. The petitioner successfully completed PST, PET and written test for ORL trade. My argument goes into. He said for the written test of the ORL. But name of so-and-so was erroneously entered as RTGCO instead of ORL. The error was noticed by the Board of Officers. Therefore, the candidate was not allowed for trade test of RTGCO. Then fourth paragraph. The candidate had cleared all tests of ORL trade. However, he was placed in low in merit against his state. Therefore, the ORL part goes. RTGCO, there was no post. He could not have been considered. On the next year.
Show me the statement.
It's gone. I'm saying it's gone, madam. My read is gone. My read is gone, is what I'm saying. That he
What
said
should
for
we-
the ORL.
Oh.
He said for the
That's what I'm
PST,
saying.
PET and
That
written.
was I was asking
My
you.
read gone. I concede my lord.
Withdraw. Or we should pass.
She could pass.
But Mr. R. Mujumdar, Learned Counsel for the petitioner. I will pass orders. Don't worry. Will not detain you.
Was it my name be recorded for?
Mr. K. Google.
He had participated in everything for the ORL.
That's what I was, Mr.
RTGCO.
Mujumdar. It's
That-
not
that
for
letter-
fun
that-
that I was telling you. I was telling you all this after going through.
Page 24, my lord, para 3, para 2 and 4 will
Finish off your case. That's why I specifically asked you whether you received. What is your statement?